Oh, hey, everybody. How we doing? Happy Friday, everyone. It's Friday, September 6th, and I am, 3 minutes late, which for me is pretty much about as on time as I'll get. So glad to see everyone here. How you guys doing? I had the week off. How was the week? For those of you in the US, how are Labor Day plans? Did Labor Day plans go through? Has your week been as crazy as mine? Has everything been insane as always? Yes, always. And I think the reason why some of the numbers might be a little low this tonight is because I'm like on time. So people thought they had like a 20-minute lead in. And I imagine that we'll see a lot of people coming up in chat relatively shortly, just going, oh, damn, well, yeah. So, how was everyone's week? Where are you guys tuning in from? Hey, Sean. Sean, yeah, Judge Summers is ruling in response. Good to see you, buddy. Carrie keeps coping. Hey, Rob. Hey, Sean. How's it going? Uh, that was a very dismissive order. And you had some news media that are eating crow right now for running with reporting that's a little bit early. So we had some premature reporting on. That's kind of why the title is what it is. It's not clickbait. It's just the media got it wrong a little bit. But go figure. Reporting on legal stuff. You might want to consult your legal team before you do that. So, anyways, how you guys doing? Where are you tuning in from? We've got people coming in from Virginia, just down the street. Susanna, Alberta. Lots of Canadians coming in. Some people expressing that I'm on time. Hello from Texas, Austin, Texas. We've got some limoncello being consumed. Phenomenal choice. I've got a red wine that's appropriately sized for the week that I had. I will say I had one of the most fun days in court this week that I've had in a very long time. Get into that in a minute. Let people mosey on in. And Trazi, hi from Germany. Thilo, I think I said that right. New Jersey, Southern Maryland for sprinkles. Tuning in. Hopefully, everyone's got a beverage cozied up and ready to talk about some developments in cases that we've been covering, as well as a new case that I was kind of intrigued out of this area. That was kind of one of the first ones I wanted to cover. Holly's a new member. Glad to see you, Holly. Thanks for becoming a member. Kristen M96. Who are you? What happened to the real Rob? You mean there'll be one I'm on time? I'm on time. Everyone's surprised right now. Yeah, no. I'm gonna try this thing of being on time. Anna Banana, Rockville, Maryland. Good to see you. Glad for you're here. Edmonton. We have another Edmonton Canadian who's probably on their way tonight. Got some Montana in the house. Denver, Colorado. Oh my gosh, you guys are all tuning in and saying, hey, what's going on? Canonical Heat is coming in with a very generous super chat. Thank you, Canonical Heat, for always giving support to the channel. Tap the bell, please do so. Hit the like button. Absolutely hit the like button. It shows people that you're here and hanging out. Subscribe wildly. It's the right thing to do, and you want to. So I very much appreciate that, Canonical Heat, and for all the love you give the channel. Much appreciated. Okay, so 3 cases I want to talk about today. Do we get right into that, or do we talk about one of the most fun days I've had in court? I think I talk about one of the most fun days I've had in court. So it's like bookended with like a bad day in court. Oh, I'll wait till Ian gets here before I tell that story about a present that I had received this week in my office. And by my office, I mean down here. We'll talk about that. So I had a day in court today that was on contested motions. And very rarely do you actually have the opportunity to argue what's called a matter of first impression. It's where there's no prior case law within the jurisdiction that actually resolves or speaks about a particular issue, right? So a case or a matter of first impression, and it was well prior to trial. So 6 months prior to trial, and we're arguing over this matter of first impression. And I happen to very much respect the attorney on the other side. Think he's a good guy, former prosecutor. We're not going to hold that against him, but very strong advocate for his client. And the two parties in this case are diametrically opposed in their positions. So going into this was set down, and again, I'll just set down for legal argument only. Legal argument only for 3 hours. Those of you who have never tried to argue something for 3 hours, it's a lot of time to be on your feet and just running at full speed. So we get into court, and lo and behold, we're in front of a judge who I had mixed feelings about. And I have now, at the conclusion of this hearing, gone very much, very much in favor of how this judge, well, how he administers his courtroom. So the judge right away goes, Mr. Morton, and then other counsel's names. You guys have been in front of me quite a bit, so you know how I like to run my courtroom. And this time I'm going to have a few more questions than I usually do. Well, that's a bit of a warning because this judge is what we call a hot bench that kind of interrupts you all the way through and just turns it over to us to start arguing. So we start arguing the motions, and then within about 10 seconds of getting into the motion, the judge is cutting us off with these really hard questions. I mean, remarkably hard questions. When I say that this area or this type of law, matter of first impression, you're arguing the principles behind the law. You're arguing why the law should be this way or it should be this way. And you're standing on a razor's edge, right? This hasn't been decided before. So you're right there on the razor's edge, and you're walking this line where there's this body of jurisprudence over here. There's this body of jurisprudence over here. No one's actually gone and talked about this particular issue. And the judge is peppering you with questions of saying, why should I side with you and not with the other side? So what it ends up being is this philosophical debate over statutory construction, legislative intent, um, and the correct interpretation of prior case law with this statute on this particular issue. The judge, throughout this argument, we actually end up finding another issue that has not been ruled on. So the judge gives us a warning about halfway through and says, counsel, I'm just giving you a warning. I know your trial date's not for several months, but I'm not going to have this opinion to you for another month or two. He says, right now, based on what I'm seeing, there's going on like 20 pages, which is very cool for a litigator, but also not, because it's really awesome to be one of the attorneys on that 20-page document that kind of sets the tone for future cases when you win. It's not awesome when you don't. But I actually think the arguments were well presented by both sides. And I have a pretty strong feeling the judge is going to make a call that's going to be the right call, irrespective of either person's personal opinion on the issue. So, like I said, it was one of the coolest moments ever. I walked out, opposing counsel walked out. Like I said, we both have respect for each other. And he turns to me and he goes, tell me that wasn't the most fun you've had in a courtroom in a long time. And I absolutely agreed. It's just arguing like crazy, getting questions that stump you, and you're taking a step back and you pause for a moment and you ask the judge, hang on, I want to go back another issue. The judge challenges your legal premise or your logic in getting your conclusion. So, like I said, it was really awesome. A lot of fun. Probably the most fun I've had in court. And on the topic of legal argument, most fun I've had in about a year. Yeah, at least. That was a good time. Anyways, apart from that, as you can see from the mess behind me, the 3D printer over there, our friends are not yet back. There's been little done in the studio because I had a golf trip last weekend for a birthday. It was a fun time, except for the fact that it happened to be the hottest, most humid experience I can recall. Wanted to die, but in a good way. Hold on. It was fun. It was a great time. Kids loved it. Beach was great. Came back to absolute chaos in the office. And here we are. Now I'm playing catch up with a ton of things that happened throughout the week and throughout all these past 2 weeks on some cases we've been covering. And it's gotten me kind of tired. Is that my new shop? No, it's not. We're in my basement office. I have been cast down to the basement where I cause the least amount of noise to the extent that there are sleeping dogs or children upstairs. And the only thing I have set up down here is a 3D printer because, you got to print stuff. The shop needs some work. So, Mickey, Ian's been working hard. What have you been doing? I know. I've been seeing Ian's been putting out videos left, right, and center. So he's working remarkably hard. Kate, is being caught up actually a thing? No? Yes? I don't know. We had to evacuate my office today. That was also weird. So there was like an arrest made or a search warrant that was executed down the street from my office, resulted in hazmat suits being brought in and a respectful request that neighboring offices and houses evacuate for a period of time. It was fun. It was really cool. So, all right. Is Leo in the cone of shame still? No, he's not. Mostly because he rejected the cone of shame to such an extent that the cone of shame was ripped to bits. Not to mention, those things fucking hurt when you get rammed into in the leg with a plastic cone of shame going 99 miles an hour from a dog that's bigger than you are. Holy crap. Paw's almost healed up. And I know we'll probably repeat this when Ian gets here, but he was not healing properly. For those of you who are wondering who Leo is, who's Leo? Do I have a picture of Leo near me in the immediate vicinity? I probably do. Give me 1 second. This freaking dog. This dog is going to, well, I'll pull this up while I'm talking about him. So Leo is a Doberman that is right now going on 9.5, 10 months. And I've never seen a dog with more energy in my whole life. Like, I just haven't. And I've seen crazy dogs before. I had a Rottweiler. I mean, I'm used to big dogs. Leo is a bona fide psychopath. Just chaos gremlin times 9 million. And he very much likes to cause chaos. Actually, you know what? We're going to do this. And I might regret this. I don't know if I'll regret this or not. Let's see. Oh, Leo. Move. No. Move to this screen. Let me see. All right. So here's the Chaos Gremlin. This was earlier today, and I was trying to share a video to demonstrate that this dog was, in fact, doing okay. Let's see. Is there audio? I don't know if there's audio that I want to hear, though. Yeah, he's doing fine. Big pup. Big pup. And right about here, I think I noticed that he's looking to do something. Yeah. Sorry. That was very immature of me. Remarkably immature of me. Crazy Cat Queen going, dude, he's just going to jump that fence eventually, right? Well, he saw a rabbit back there earlier today and damn near took the fence down. He damn near took the fence down, just sprinting towards that rabbit. Yeah. Just because he's a crazy dog. It just happens. Sorry. I saw it. You had to see it. That's how that works. Dog. But he's a big, handsome boy It's all sorts of crazy and adds chaos to our lives. Sometimes great, sometimes not so great. All right. In other news, oh wait, here we can do a cute. Just we'll do a palette cleanse photo of Leo. We'll do a palette cleanse photo of Leo just because so many people are probably really mad at me right now. So big dog sleeps small. So there's your palette cleanse. Big Leo sleeps small. So that's Leo. He had a busted paw, split it open, and because he's a crazy dog, we had it stitched up. It was impossible to keep him from going crazy. And within, I want to say about a day and a half, he had torn the stitches on the paw. That was cool. So we went to the vet again. Disgusting amounts of money to get surgery on dogs or stitches on dogs. Go to the vet again, and the vet goes, "We might need some pharmaceutical assistance to keep him calm." And both Mischief and I go, "Thank God, we were hoping you were going to say something because we didn't want to have to ask and make it sound like we were just trying to drug our dog. But there's no way this dog is going to have stitches. They're going to stay in for another week or two without some medical assistance." So the vet prescribed said medical assistance, which was to give 1 to 3 trazodone 2 times a day, gabapentin, another pain medication, and then a antibiotic. The the trazodone, the doctor originally said 1 to 2, and then the doctor during the phone call said you might consider 3. Let me tell you what happens to this dog on 3 trazodone. Any of y'all have kids? Any of y'all have children or recall having children that were of the crazy little young boy variety? I'm talking about the age of 5 to 7, just right around there, where there's this wild energy they get when they're really tired. You're not sure where it comes from because all of a sudden it's just like they're sleepy, but they're not. And when they're not, or when they're fighting that sleep, they become very hyper, not just zoomies. I'm talking, holy crap. This dog on 3 trazodone is jumping around the house like he's a monkey. Oh my God, it's so crazy. Oh, it's so crazy. Like his eyes are like drooping and he's like, I want to be asleep, but I don't want to be asleep. I want to be awake. Yeah. So that was my week. It was our week. Oh, ADHD Leo. Yeah. Pretty much overstimulated pup. Okay. All right. Let's do this. Let's go ahead, get caught up on some super chats and roll to our first topic of the evening. Catching up Donna Williams, Dana Williams tonight. My husband and I are picking up our first dog ever tonight. He's on a bus from Texas and is expected in Pennsylvania at 3 a.m. He's 4 and has a bunch of issues. He's had a tough life. We're going to love him and spoil him for the rest of it. I love it. I think that's a phenomenal idea, and I love that. I know that's going to take some patience, but that pup deserves all the love in the world. Lone Star Living, love some F&F. Thank you very much, and thank you for the gifted memberships. Much appreciated. Liz McPhail. McFall. I don't know why I said that. That's very rude of me. You have not failed. You are Liz McFall. Glad to end this week with a little F&F. Yippee, yippee indeed. Canonical Heat, thank you for the gifted memberships. Pamela Weisenbach, thank you for the gifted memberships. Fiona W., thank you for the gifted memberships. Sandy coming in here saying, welcome everyone. Please hit that like button and the sparkle fart emoji. Fiona Boyd Bell, Auckland, New Zealand have been binging on the Paralympics. There's been some cool stories out of that too. Phoenix, glad to see you back. Glad to be back. Thank you, Phoenix. Mod Princess, Minnesota with Ziggy. Emily Aarons, how do I choose between F&F and the Packers? Well, There are many football jokes I can make, but the good news is you can come back on Replay Crew here anytime. Babs Austin, a year and 2 months. How sweet it is. Thank you for being a member, Babs. Much appreciated. Joshua, thank you for gifting memberships. My mods, why are you guys gifting memberships? You are too freaking nice. You already do all the tons of stuff for me already. Baby steps. It's good to see you. Hope you're getting settled and comfy. I'm coming in from Southern California. It's been a process. I now understand why it takes families so long to unpack. I have not had to do a move in quite many years, and it's very frustrating. Scooby-Doo, great to see you, Rob. Thank you for being here. Kaylee, LMHC, trained to be social invest, GAL, do or do not. Oh, licensed mental health counselor. I imagine that's what that is. Do I want to train to be a social investigator, a GAL, or do I not? That really depends. That training and what you will see in that area will be very unpleasant. There will be a lot more sad stories than there are positive, but the positive ones they leave a more lasting mark, and you feel like you're doing something a little bit more. So for me, if you can emotionally handle it, do it. That would be my call. Patty Hoffman, Leo needs to have his lawyer present. Nah, that was not a custodial interrogation. There's no right to counsel during that. That was just remarks being made in a public forum about activities that he was engaging in a public setting that were free to be videotaped because he was engaging in this public setting. There was no expectation of privacy. Except for the sleep photo. But that was cute. That wasn't disparaging. Bop it. Leo is the goodest boy. Us pups stand together. He is a good boy. A little crazy, but good boy. Derek Thaxton, thanks for being a member. Billy's Momzilla, how can Sarah Boone be charged with murder if he got in the suitcase willingly, morally guilty for not letting him out, but legally? We'll get to that because we've got some Boone stuff to cover, including a new attorney who had a press conference. We'll go through that one. Amy Kimball, I'm going to save that question too, Billy's Momzilla. Bring it back up. Amy Kimball, our dog had 2 TPLO surgeries this year. So expensive. It is. Wow, is it not cheap? Kathy Brewer, thanks for being a member for 10 months. Much appreciated. Glad to see you here. Lynn, hey, Rob, missed you. Celebrating the night. My DIL daughter-in-law finally got her visa, and she's flying out to the U.S. tonight. That's awesome news. Congratulations. That's really cool. Torin 3 finally got discharged from the hospital yesterday. Still no idea what caused it, but looks like I'm still improving. I saw that note. I hope you're okay. That's a scary experience. I'm glad that you're okay and out of the hospital. Just be careful, please, Torin. Mary Coppola, saw an SUV today in the corner of the lift gate. It said mischief managed. LOL, not manager. You need this. I actually might. That's pretty good. That's pretty good. Okay, let's swoop. Let's get to our first story, which is a little bit, not depressing, but interesting. I'll say this one is factually interesting. So swoop. All right, so the first topic that I want to talk about today was something local down here. And I don't know if you guys have seen the news on this, but what's the best article to bring up to try and give us a synopsis? How about WUSA 9? You know what? Timeline. All right, so we'll go to local reporting in a little bit, but this case here is about the disappearance of an individual in my neck of the woods, Northern Virginia. So a timeline of the investigation into the missing Virginia mother whose husband is now accused of killing her in their home. So this is the individual who is arrested, Naresh Bhatt. Okay. So the week after Naresh Bhatt told news reporters he was, quote, suffering as authorities searched for his missing Virginia wife, he stood before a judge on Friday, facing accusations he killed her inside their home and dragged her body outside in late July. Naresh Bhatt has not been formally charged with murder in connection with the alleged killing of Mamta Bhatt, a 28-year-old mother. He faces felony charge of prohibition against concealment of a body. If you guys are starting to recall another case we covered, Zachariah Anderson, you're not far off of how I felt when I first saw this story being reported. So, concealment of a body was taken away in handcuffs on Thursday. That was 2 weeks ago, 2.5 weeks ago, and authorities executed a search warrant at the couple's home. So, let's see. We'll get to some of these comments in a minute. But let's take a look at the reporting itself or the timeline. So, July 27th of this year, Kafle Bhatt, I'm probably butchering that name, probably just really screwing that name up, was last seen on July 27th at UVA Health Prince William Medical Center in Manassas. She worked there as a registered nurse in the medical surgical unit. And then the next day, she spoke to her friend. And the same day, she posted a final video on her TikTok account showing herself and her daughter, according to CNN. So the quote from the source, I last heard from her personally on July 28th. She called me a couple times, but I was asleep. And I got a call from someone I met at the baby shower, and she asked me if I knew where she was. She's not an impulsive person. She's a very responsible person. She's a very calm person. So to hear that she might be missing, I really doubt she would run away. So that was July 28th. So now we're 3 days in. July 30th, criminal complaint says that they are saying the murder took place on or around July 30th. Said that he was seen at a Walmart on July 30th buying a pack of 3 knives, 2 of which were unaccounted for after the search warrant. A day later, he was seen at another Walmart buying cleaning supplies. Again, starting to feel like it might have some connections to what we saw in Zachary Anderson, but a little bit different when we start to get the facts. So the husband then says he saw his wife on July 31st. August 1st, police visit the house. The coworkers had been calling in for a wellness check. So now we're 5 days in. They say they worked 2 days a week at the hospital and was expected to work on August 1st and 2nd, but got concerned when she did not call or show up to work. So that's a red flag. Police spoke with Bhatt. He provided additional information and told investigators he didn't want to report her as missing at the time. All right, a few more days passed. 3 days after police welfare check, Bhatt reported his wife missing and told police he last saw her at the dinner table on July 31st. Said he had not seen her since and stopped cooperating with investigators, according to the police. Did an exhaustive investigation from August 5th to 8th, and they said and found there was significant lack of recent contact between the wife and her family, friends, employer, and social media. So they elevated her missing status to involuntary/critical missing person. All right, so she's elevated after this investigation for the next 3 days. So now we've got the timeline from July 27th up and through August 8th. August 14th. Now we get into some stuff that's going to piss people off. August 14th, in an interview with WUSA on August 14th, Bhatt said he ate dinner with his wife on July 31st when he last saw her. And he says it's like very tough. We ate on the evening of Wednesday. She was the one who cooked and do the kitchen stuff. We do not have any specific conversation. We do not have any argument or something like that. Now, Bhatt needs a Nepalese interpreter for court proceedings. So if you see a language disconnect, there is a disconnect in language. So he said his wife of 3 years is a special person who is caring and loving. She's gone missing 3 times before, he said. It had never been for such a long period of time. Quote, she did not come back and I just searched around. The next day, police came and police told me that she was not at work, and I was very serious because she's the one who would never leave her work. Okay. So in an interview with the news, Bhatt then shares a message to his wife, which, if you are following the allegations, is pretty not great. Hey, just come back. I'm myself and my baby. We are waiting like every second, every minute. We are waiting. If you are listening, we are waiting here for you. We need you. August 15th, the police sent out a news release asking for the public's help in locating her, releasing information about the wellness check, etc. So, first, this is the kind of summary. When investigating, they said they didn't elevate beyond missing person. They then followed standard operating procedure, and she was entered a missing person, statewide missing persons database. They distributed the database, and now they're just trying to figure out. They elevate it as of that later August date to involuntary/critical missing person status. August 21. Now this gets not good for the husband. August 21, The couple's home was searched by detectives, and though no details were provided at the time about the evidence leading to the arrest, investigators have since executed 10 search warrants and conducted hundreds of interviews related to this case. When asked Wednesday if there was a person of interest, they said that uh, the husband has been a person of interest and everybody knows that. She said the husband has not been cooperative, departure from the department's initial release, uh, where they said the husband, friends, and coworkers have all been cooperative. So now it's clear that the police are starting to point their eyes back at the husband after believing that he was just being a nice guy. August 22nd, they arrest and take Bhatt away in handcuffs. They also carry out the infant child under a yellow blanket. There's a caregiver. Oh, so the child's in the care of DSS right now. So Department of Social Services comes in, takes care of the child. There's probably a placement right now if there's not close family available. I don't know if there's any immediate family in the area, but there would be an immediate family placement, or the child be placed in temporary foster care while they're awaiting any of this stuff to get resolved. News release, the police chief says, while I acknowledge and respect the public concern for answers, I assure each of you that although these, quote, answers are limited by this continuing to be active and ongoing process, the investigation remains a top priority, and our agency remains committed to providing details as we are able. Okay, so are you following timelines here? Because now we've got an arrest August 22nd. So we've got an arrest and okay, just want to pull up the statute. So August 23rd, they come out, or the court documents that they get obtained by CNN. So the court documents cite evidence in the residence indicating the body was inside the residence and dragged out of the residence, which is a handwritten addition to the statement that was signed by the charging officer. Let me see if I've got that. Actually, I had that pulled up. So here's the charging instrument. Let's zoom in. So right now, when people are wondering what a criminal complaint looks like and what it looks like when someone's just charged, originally just arrested, in Virginia, it's this. It's a one-pager. Now you can go with an indictment in circuit court. You can get a grand jury to prepare an indictment. And that's how you end up getting the charges brought up to circuit court and initially commenced in circuit court. But this was initiated in juvenile domestic relations district court. The reason why is because the allegations of the conduct were as between family members. So the allegations are as follows. On or about July 30th, the accused, Naresh Bhatt, murdered his wife. The incident occurred at the residence located at blank in the city of Manassas Park. During the course of this investigation, a substantial amount of digital and forensic evidence consistent with her death was recovered. Then there's a little write-in section. There was evidence in the residence indicating the body was inside the residence and dragged out of the residence. And that's the additional. That's not ON, that's actually CV. Those are the initials of the arresting officer. C. Ventura is the officer that signed for the actual warrant. So there you go. That's the arrest warrant. So that's just straight from that document. So during the arraignment of the complaint goes on to say there's a bunch of digital and forensic evidence consistent with her death. I think that's an amended complaint. During his arraignment, the judge didn't change the terms of the bail, so he's held without bail. I would say that, yes, that would be the appropriate hold. And the defense argued there was insufficient evidence, couldn't hold over, standard defense arguments. But here's what's interesting about what we're seeing from the investigators. Investigators say that there was a number of inconsistent statements about his wife's whereabouts. All right, standalone, not a big problem. He claimed that she destroyed her own cell phone before disappearing. Now we're a little bit of a stretch the what we believe to be true or not. After completing the search warrant, investigators found what appeared to be blood pooling and blood spatter in the home's main bedroom. The bed appeared to be moved, blocking the closet, and light pink stains were found on bedroom carpeting after the bed was removed. Additionally, pools of blood were found in the bathroom, as if something was dragged across the floor. When investigators removed the bathtub, they saw what they believed to be blood in the caulking of the bathtub. Remember, I told you that when they look for blood, they find blood. It's part of that. A number of cleaning supplies were purchased were also found in the home, which appear to be in disarray. He said that he sold his Tesla on August 19th, and the house appeared to be disheveled with a suitcase packed, items missing from hangers, etc. August 26th, Bhatt is ordered to be held without bail. Okay, so that's where we are as of late August. Now, where are we today? Why am I kind of keeping an eye on this case right now? Because I think his attorney is playing things legally smart. So he has a public defender that's appointed for him right now. And a couple of motions get filed. So one of these motions here that was kind of interesting to me was this notice in motion to waive the grand jury. So what this is essentially consenting. You are agreeing to forego the indictment. Now, why would someone do that? Because in Virginia, you have an obligation under speedy trial statute to commence a trial within 5 months of the indictment or the preliminary hearing date. So they waived prelim, they waived indictment. They want this 5 months to be calculated back to that original complaint date. Now, speedy trial is both a hindrance to the defense, who's limited in their time to prepare for a case, but also a hindrance in the prosecution, especially in a case like this. So in a case like this, where there's already, as we've seen through this reporting, there's already very little that they've got. They've got some information, but it seems like they're still conducting a bunch of searches. And as we're going to read here, they're conducting a lot more. So that 5-month period begins as of the date of that criminal complaint. So we're now back to that criminal complaint. August 22nd is the date. If you were setting up the indictment, then you're basically giving the prosecution more time to put their case for the indictment. You get the grand jury impaneled another month, another 2 months. So the prosecution at the whole point in time, the investigation is continuing to go on and search for these things that they would need to prove their case. But by waiving that and setting that clock and moving quickly, there you go. You're now taking a case where the prosecution has limited evidence and you're telling them to prepare their case in this time period allotted. How do I get that impression? Well, because I think we had 4 search warrants executed this week. So more than a month after her disappearance, police were back at the community Thursday searching for additional evidence in the case of Mamta Bhatt. They searched the area surrounding the Manassas Christian School, Camp Carondelet, and a portion of Blooms Park. The school itself moves locations. The building appears to be vacant. So they're searching these locations of interest, trying to find any information they can that would tie him to making her disappear or not alive. So right now, in the wake of this, they're executing search warrants like crazy. This stuff's a little bit different in every single case. Usually when you have a case that you're worried about, you want to get all of your information before you bring the charges. Those cases that are kind of on the cusp. But sometimes there's cases where you have a legitimate concern, as I believe was the case here, where the person who's the suspect in the case is the concern is they're going to flee. You're concerned that if you don't bring the charges and initiate the arrest, they're not going to be there to charge. And now you're going to be searching for them. So it's this weighing game of when do I bring the charges and arrest this dude, no matter what information I've got. And I might not have enough to prove the murder, but I might have enough to prove something, to prove enough to keep him detained so that I can continue my investigation. So they're still looking like crazy for this information. The only charge that he's facing right now is concealing a body. That is the only charge that he is facing. So the defense counsel is arguing what we would think, that they're missing the primary evidence, namely the body. They're planning for a 6-day jury trial. Remember, I said that these trials don't usually go for like 6-7 weeks, that they're usually a couple of days. This is more in line. A 6-day jury trial is more appropriate in this regard. Married for 3 years. Naresh Bhatt was an automated logistics specialist in the Army Reserve from June 2017 to February 2024. Left the Army in the rank of specialist. So this is a case that I'm curious about because I want to see how this plays out. When you see cases that are brought and argued on this speedy trial tactic where you have an accelerated time frame, things develop very quickly. I mean, if you think about starting a trial within 5 months, look at this, the term date that this is set on. Return a case. This is set for term day, which is setting the actual trial date. It's set for term day on October 8th after the grand jury was going to return, but I think they're going to set a trial date now. Got another motion coming up on the 16th. So, that's where we are with that case. I think it's going to be very interesting to follow. I'm very curious as to how that investigation is going to go forward. These cases, I mean, we saw it with the Zachariah Anderson case, and I think we saw a very different case there than we do here. In the Zachariah Anderson case, it's going to be interesting to see what the Commonwealth's attorney brings in this case when they bring it up, because we heard the description of pools of blood, right? But in the Zachariah Anderson case, they tried to explain significant amounts of blood, but the evidence that they presented at trial was not that. It was not consistent with what was being portrayed in the media outside of that. So I am waiting for this trial to move forward. I think it was the right tactic for the defense to say, we're not waiving speedy trial. We want you to push this case. Now, the defense can always come back and say, no, we're going to delay. But right now, the tactic is push forward. And the police are investigating to the extent that they can find additional information to plug those gaps that they don't already have filled. So that is where we are on that particular case. Any questions on that case, or should we move on? Because my gosh, kind of interesting. Ian is citing his new scope right now. It's a very strange thing to get when you have a friend who's doing this kind of stuff. Late today. What are you going to do? I'll be there. I'm just going to go get my scope sighted in. Cool. Got it. I'm missing the jury box too. Trust me. I'll end up working it out. This is Manassas. Yes, it's Manassas Park. So all of this is Prince William County. Concealing a body and no bail. I think the risk there is the evidence they put on a flight, the attempt to sell the car, or the sale of the car, and the attempt to sell the house, I believe, was also on there. So there were efforts to get rid of property and start to get out of the area. I think that's what they were trying to. Gen V, he was clearly trying to flee. I think that's what they were presenting to the judge, and I think that's why the judge ordered no bail. So apparently, the hearing that occurred yesterday or 2 days ago, they were waiting an hour and a half for a Nepalese interpreter. So I don't think that mistake's going to repeat itself in the future, but I didn't realize that Nepalese interpreters were that hard to come by. I mean, not to say it that way. In the DC area, we have interpreters of all kinds of languages all over. A lot of Amharic interpreters. So Spanish, obviously, any number of. So let's get caught up. Let's move on to Boone, maybe. Okay, that's fair. I could take that. I like the question. How much blood is a pool of blood? Yeah, yeah, yeah. There you go, Loretta. What an interesting question. What a very interesting question. How can they charge him with hiding a body if they don't know where the body is? That's the question the defense counsel is trying to make. But to get to a trial, you don't have to prove beyond a reasonable doubt that the body was hidden as of that moment that you're charging him. You only have to prove sufficient evidence to move forward with the trial. You only have to basically reach that probable cause standard that you have satisfactorily provided evidence giving rise to probable cause that this occurred in order to move forward and hold over for trial. Very low standard, not that high of standard. And in this case, when you add up the knives purchased from Walmart, the attempt to sell the vehicle, the statement that she destroyed her own phone, the denial, the inconsistent statements by the husband as to where she was or when he last saw her, and then the forensic evidence of the blood located within the home. I think that gives you enough to at least hold him over for trial. Do I think that's enough to convict him beyond a reasonable doubt that he's actually engaged in this? Nope. I don't think it is. Could you convince a jury? Probably. But I don't think it's enough for beyond reasonable doubt, which is why I think the prosecution and the police are investigating so fervently right now because they're trying to fill those missing pieces. And Steve A is right where I am. Probable cause to get arrest trial. Yep. Conviction. Another story. I agree. I 100% agree. So, and then this is another one that I also agree with, James. James Radoff, more charges will come. They likely will. You'll probably see a superseding indictment, something to that effect, arguing more charges because once that's the thing, you want that speedy trial toll to run. And as that speedy trial thing is ticking away, if you're a defense counsel, you're kind of saying they're not going to find anything else because if they find something else, they can issue a superseding charge or a superseding indictment that lumps in additional charges, which can reset the clock depending on the circumstances. Honestly, it's crazy if you think that you're defending against a single charge of concealing a body, and then let's say a month before trial, they will tack on 6 different charges. You would have to ask for a continuance at that point if you're defense counsel. There's no way you could go forward with trial at that point. So it basically is a de facto stop of the speedy trial. So we'll be curious to see how that ends up working and kind of how they're going to go about that. Let's see. Get caught up. All right. Let's go ahead and swoop and talk about Sarah Boone. Sarah Boone. Oh, Sarah Boone, Sarah Boone. How are you today? Doing a lot better than you were a couple weeks ago. Sarah Boone. For those of you who are playing catch up on Sarah Boone, not catch up as in the packet you put on French fries, but catch up as in trying to play catch up on where things stand in the case of Sarah Boone. I think the last time that I covered this case, we were talking about, where was it? Last time I covered it, let me just pull this up. No. Where was the letter? I got it saved. Give me 1 second. So Sarah Boone is set for trial on October 7th. I believe October 7th. And the last that I had talked about her, she had written a letter to the court that resulted in her losing the right to counsel. Well, not losing, waiving by her own conduct the right to counsel. And in that letter and in the subsequent letter, you know what? This is going to drive me nuts. And it's probably driving you nuts hearing me talk about and go on and on and on. I promise we're not always this disorganized, but it's been some time since I've done this because moving is insanity and all of the above. Sarah Boone, where did you go? Where did you go, dear Sarah Boone? I had you. There we are, the 58-page letter. Why was it 58 pages? I don't know. Because you needed 58 pages of nonsense to put upon the public an advertisement. Sorry for the accent. It's terrible. I know. I get it. Let me do the letter. Where's the letter? Where's the letter? Where's the letter? Share the screen. Nope. Yes. Nope. Why did you not see that? There. Yes. There. 2. So June 7th was the last time. June 28th was the last time I covered this case. So by regular correspondence, hand delivered, Sarah Boone. You have to appreciate the penmanship. And this was a decision. I don't know that I agree with it, but it was a decision. I like that she actually put here total number of pages 58. Legal correspondence, regular correspondence. Okay. Then it was this all, why can't I use my constitutional rights, use the all the above? Why can't I do this? Why can't I do that? Why won't my attorney do these things for me? We went through this before. It was a very, very long letter. Again, 58 pages. For those of you who don't believe me, we're going to go ahead and zoom. Look, 58. All the pages of Sarah Boone's letters. I don't remember the last time I had to write 58 pages in handwritten, penmanship like that. But that was something. Now, where is the advertisement? These are the maps. Oh no, it was after this letter. That's right. It was after this letter that she asked the judge to put up an ad. People are asking why the maps? Because the maps are telling the judge where all of her fans are. People that would pay for her attorney. Yeah. That's where she said all of her fans were. So let's do this. Let's see. I've got a lovely bunch of coconuts. Deedly-dee, there they're all standing in a row. Big ones, small ones, some the size of your head. Because here's the thing. And this letter resulted in Sarah Boone waiving her right to counsel. Because the judge was like, nope, we're not letting you just completely run over this over and over and over again. You've been through your 8th attorney at this point in time. We're just done. We're just plain and simple done. And that resulted in the judge entering this order, which articulated a very high standard for waiving the right to counsel. How does one actually waive their constitutional right to counsel? By their own conduct. 16-page letter that went through the high burden the judge was facing in making that determination, and in turn determined that, in fact, Sarah Boone, by her own conduct, had waived her right to counsel. After Sarah Boone received that order, she was not happy, and then told, and I'm sorry I'm taking so long to get this. I actually hadn't thought about this until I saw the interview with the new attorney as to why he got involved in the case. And it's important because every now and then there are things that just surprise you. Order setting hearing. There we go. Nope, that was her asking for headphones. That was her request to jail. That was all the stuff she wanted from the jail. She wanted everything from the jail. Freedom of movement, formal address correction. Nope, saw that part too. Scheduling order, court minutes, notice, response, seeking due process costs. Yes, yes, yes. Got it. Correspondence received. Circuit Court, temporary motion for reservation of proposed costs. Nope, we saw that one. That was actually pretty well drafted. Motion requesting immediate relief to a defendant by appointing effective standby counsel. Nope, that was actually somewhat well prepared while not really understanding what it was that standby counsel was. It was, I found it. Yes. Found it. I knew it. Because there's a way that I've seen people try to get attorneys, right? Try to persuade them to take their case. This was rather interesting. Make sure y'all can still see this. Let's go ahead and eliminate these sidebars and go through at least part of it that I think is rather fascinating. So where's my discovery? Where's all this other stuff? Judge Kranick, I am, this is a big problem for me. I don't even know what's contained in those documents. I can't see them. I don't know. Please note, I don't have access to a computer to review these materials. Do my very best to figure this and event everything else out as I go in my newly unwanted forced position of pro se. Please do not penalize me even greater than being already. I'm trying. Please know also, I'm in an open bay. Okay, got it. Then she addresses this part of her letter to her former counsel, Cashman. I'm glad I could help you shine in the courtroom in front of the judge by you professionally and finally bringing everything I've been asking for since day one. And after I included you on my letter to the judge, ensuring return, unlike you, who did not include me on your motion to withdraw. Surprise. Quite the character. Quite the character indeed. Anyways, as the clock ticks onward, posting in public. Remember, please, Judge Kranick, fair, neutral, impartial, you must be always. So she asks the judge to kindly post this advertisement in judicial chambers. Well, the judge didn't have to do that because it was actually just publicly filed. Inmate seeks attorney. Looking for a prosperous challenge ready for your close up on national television? Are you zealous with a side of keen? Show the world who you are with your star original creativity, star extraordinary expertise, star confident ingenuity. Honestly, pretty creative qualifiers there. Qualifications must include being trustworthy, honest, passion driven, open minded, exceptional problem solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency in listening, communicating, understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, committed, maintaining faith in bold in the client and case with the ability to think differently, overcome all circumstances. Epic opportunity awaits. Sarah Boone, inmate number 2000563, Orange County Corrections Department. Invest in the oppressed. Believe. I'm not going to lie. This was all right. So these qualifications, one, you have to appreciate the artwork, right? This is pretty good. Well drawn. And does this looks like you're applying for an internship. I don't know, at like a Funland or something. I don't know. What are we doing here? Are you zealous with a side of keen? Show the world who you are with your original creativity. This isn't arts and crafts. Confident ingenuity. Extraordinary expertise. The qualifications must include you have to be trustworthy. You know what? If you're representing Sarah Boone, I will give you this. You have to have exceptional problem solving skills. Exceptional problem solving skills. So this one, she hits just right on the mark. Like kudos, just boom, right there. Extremely efficient in listening, communicating, understanding. I would say you have to be extremely efficient communicating. Yep. So that was the want ad. Why did I spend so much time bringing that up? Well, Rob, you spent a lot of time on a lot of stuff. Understood. I take that criticism, and I actually think it's fair. But what we've got now is dun 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 new counsel. New counsel has noted an appearance. James Owens. James Owens, come on down. Come on down to the ever rotating cycle of trial counsel for Miss Sarah Boone. How long you'll last, nobody knows. We don't know at all. But said attorney begins filing motions. Where was it? Just retained. Wants the information filed. Wants the appointment of crime scene investigator. And wants additional discovery. Also wants, this was one of the curious things to me. So several motions have been filed in the time since that attorney has noted an appearance. And it was where was it? The motion for the appointment. Yes, of the crime scene reconstruction and death investigator. I don't know why, but I guess they want to investigate the crime scene. I mean, this one is pretty straightforward. It's on the cell phone of the boyfriend locked up in the suitcase. So I don't know that that's going to do a lot. But again, it's not the most amount of money. If you look at this cap of $6,000, it's not terrible. Then they've also want more particular statement as to the charges or the charge defense. And then they filed this motion to continue. Defendant set for trial beginning October 7th, 2024. Defendant's just retained defense counsel. Notice appearance was filed on Friday, August 30th. 38 days but remain before trial. This is a holy crap. 38 days prior to trial when this motion was filed. Defense counsel has met with defendant 4 times at the Orange County Jail. That's funny because there was another document filed, I think, yesterday. So during these meetings, the defendant disclosed potentially exculpatory evidence on her phone in the possession of the Orange County Sheriff's Office. Evidence include photographs, videotapes, calendars, text messages, notes, and witness names and numbers. The evidence will potentially corroborate her anticipated battered spouse syndrome defense. So that's before they filed the formal indication with the court they were going to use that defense. But you had a heads up. I mean, we've been speculating on it the entire time that that's what she's wanted to use. But I think that there's some very, very big hurdles in getting there. But anyways, this defense counsel has been retained, is now in on the case. And after the hearing, we'll watch the hearing. Let's do this. We'll pull the hearing up. I actually haven't seen the video of the hearing. So this is going to be you and I watching this one for the first time. We'll bump around a little bit. I don't know that there was too much. We're not going to watch a whole hour of a hearing right now. But hopefully y'all can hear this. Once audio gets played. Is audio playing? It's not playing on this tab. Hang on. Let me fix this. Refresh. It wasn't my computer issue. It was that this hearing goes on for 30 minutes without a single. So let's go ahead and catch up where we are. Let's see Sarah Boone walk into court. I know that I don't have the screen shared right now. I will fix that momentarily. Oh, wait, hang on. Them arguing, I'll get to that in a second. Don't worry. I'll get to that. But here's the hearing. Here comes Sarah Boone. See it and smiling at the bailiff. I don't know. The bailiff did not return that smile. But the judge is about to come in, announce their presence, announce the case, call the case. Case Porter versus Sarah Boone. What was that? Maybe don't make faces.
Sir, good morning. Pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now. First, going to go ahead and swear you in.
Can we hear the audio? Is the audio high enough or do I need to gain it up?
Or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that?
Okay, so we had the evidence viewing. She was present for that. We had a discussion about what evidence was going to be viewed.
Viewing.
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense that was filed on 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously.
Man alive, we have an attorney. Thank the heaven above, we have an attorney. We have an attorney making motions and arguing logical. Thank you.
I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I post them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the
Morning, sir.
hearing.
Thank you. The only thing I saw in the court file, counsel, when I was prepping last night was the motion for statement of particulars, the call on September 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed at 8:10 yesterday, but I do not have the motion for additional discovery filed at 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, the other 3 aren't.
No,
They were all filed yesterday, 19.
certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They're not here. Your motions for these various experts report that they were sent to all persons on the service list through the e-portal. But I don't know how I can address these this morning without having JACS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I have, I filed my notice of appearance on Friday,
Yes,
and I've spoken with Dr. Runkle 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Runkle. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing them to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent a notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and he can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Is your office?
Office in the building?
Yes, it's in the courthouse.
Right there. Come out front door, make a left.
Okay.
I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., state of you the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally and in writing, given the lack of time we've had to prepare or to make a good formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and the motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, state, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JACS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing the defense. And there's a second doctor, Dr. Michael Brandon.
Spell that out for me, sir.
Dr. Michael Brandon,
B-R-A-N-N-E-N?
he spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marcia Thompson case. That was the Palm Beach County first degree murder where she shot and
I didn't even see you.
I snuck in.
I was reading a Florida Supreme Court case on trying to get to the battered spouse defense so I could find the elements to explain to people what was being proven, and then all of a sudden I hear a beep and there you are. So, Sarah Boone, hey buddy, how you doing?
I'm doing all right. Now, if you started at your usual time, I probably missed, 15, 20 minutes?
False. I started at 8:33.
Okay, nice.
I know. It ended up working phenomenally. But Sarah Boone has an attorney. Thank the Lord Almighty. Sarah Boone has an attorney.
Has 2 attorneys.
I know. It's awesome. And they seem competent.
I was actually
great.
super surprised because they showed up and they're like, here's an appropriate motion. And because
4
they
of
asked
them.
for a continuance and the judge said no.
They
and
asked
they're
for
like,
discovery.
And of course they're going to get discovery. But
Yep.
the judge was, when they said no to, when the judge said no, he was just like, okay, we'll deal with that. And I was like, this is a guy who's used to rolling with punches, because I kind of expected a wee little tantrum. And no, he seems to be on the ball. I was pretty thrilled by that. So, I was, I'm impressed.
So
I hope it goes smoothly.
He denies continuance towards the end of the hearing, right? No, not really. Let me see. I think we're actually pretty close. Let me see.
killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
Like guys locked in a suitcase, and
Florida's interesting on this.
Mr. Brandon this weekend unsuccessfully, and my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. I will be, that's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burke. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these 2. As well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports the prior domestic violence arrest of Mr. Torres, as well as the officers involved and their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome. that we have cooperation. It's gonna take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm gonna have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm gonna have to file something. He
The
says
judge
he's
just
still
looks
got
so
20
tired of
hours
this
to
shit.
work under that original cap.
Yeah.
So, I'll be filing something today or tomorrow as it relates to that. But that's the only other, of course, I've been retained, so I'm not gonna make any claims for attorney's fees. I'm not making any claims for travel costs.
So he's going through all the motions to, we'll just get to the punchline. The motion to continue gets
Dr.
denied.
Robert, she needs more time. Dr. Brand needs more time.
All right, thank you. State anything else?
No,
All right, thank you very much. All right, Mr. Oates, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, have such extraordinarily good cause, and such extraordinarily good cause would.
Her demeanor from the beginning of this hearing until now, like, is 180 degrees. Beginning of this hearing, she was cheery and chipper and like she was feeling all the confidence in the world. Now that she's seeing no, just because my attorney is saying a lot of really good things, I am not getting everything that I could possibly get in the world. And I am still facing a murder trial in 2 months, month and a half. Not even.
I mean,
Holy
it's
crap. A month and 2
gonna
days.
be rough.
32 days from now, I think. 31 days. This is not going to be easy.
Not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list, disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's.
You get the impression this judge had this recitation kind of
Oh yeah.
offhand, like knew how they were going to rule, but gave the attorney the benefit of the doubt in making the argument. But this was writing on the wall.
June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist.
I like how he's got it written down already.
By Tricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz, Dr. Jury specializes in battered wife or battered spouse syndrome. Once by Dr. Mankiewicz Mr. Mankiewicz, on July 17, 2023 again, by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barlow v. State 221 Southern 3rd 562 and 569, there's a two-part test determining the need of experts. We're not going to be addressing that today as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Ramos versus State, 75 Southern 3rd, 1277, and pinpoint 1281, by the Florida 4th DCA 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change in counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case...
That was a very specific number, Judge. You had that one.
...specifically set for trial on October 7th.
She's not looking
June
happy.
28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial was counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Mankiewicz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed by
Should I throw a video live?
Counsels, as established by counsel's
Yes.
representations in various hearings.
I can redirect to it.
Motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her
Done.
possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise.
Oh, you never want to hear that.
October 15th, 1986.
You never want to
Were
hear
you
the
duly
court's done its own
public defender of
research.
the First Judicial Circuit in the state of Florida from 2009 to 2012. You've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. In considering all the factors as set forth in terms of the state 311 Southern 3rd 185 and 189, Florida 2nd DCA 2020, your motion for continuance is denied. This trial is still set for October 7th. We will have pre-trial the 6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County before Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covered, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request that I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion, then provide a form order, I'll sign it, and you can.
All right, that's enough of this hearing. So what you get out of this hearing is that this guy knows what he's doing. That dialogue between judge and attorney are honestly what you see on a daily basis of people that know how the practice works. It's well argued, well taken.
I really like just, the lawyer makes good arguments. He doesn't win. But I mean, if she fires him, the problem is that she is not making good decisions, so she might fire him. But like if she fires him, it is really, really like why?
There's a fist bump at the end, apparently.
What? Why is there
Or
a
is
fist
it-
bump at the end?
Is there here like a fist bump?
Motion for statement of particulars and motion for additional discovery. Parties having no business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
That's not weird. I mean, she's in handcuffs. And the other thing is, if you open your hand to go in there with an open hand to someone that's in handcuffs, the deputy gets kind of nervous that you might be trying to pass something. So I don't see anything wrong with that. Now, what I did find fascinating is, have you seen reports of what occurred in the, well, we'll get to that. We'll get to that now. So as to the individuals that we're talking about earlier communicating about some strife or conflict between counsel. One, I'm going to give you, yes, we get the press conference, don't worry, but I'm also going to read something that was filed, I believe. No, I need this. There you go. Thank you very much. Much appreciated. Thank you, Adobe, for participating and cooperating in tonight's live stream. Your cooperation is much appreciated. So, notice of filing. This was filed on the 3rd, so just 3 days ago. And I was curious why it was filed. I didn't really understand it. Reading through IMS record of the jail per memorandum from the Orange County Corrections Department, apparently there was an incident report at the jail that they felt they needed to file something with the court just to indicate there was an incident that was reported. So you have this inmate behavior notes. Now, this is taken with regard to every single inmate that's reported by the individual that are staff at the jail, the jailhouse staff, corrections officers, reporting inmate movement, whether books are requested, materials are requested, etc. Okay, so fairly standard. So you've got the inmate notes, and what's interesting is this interaction. So Ms. Boone receives 3 USBs, 1 hard drive, 1 extension cord, 1 laptop. All right, great. She gets this in material, 10:46 p.m. Or no, that was 2,200 hours. So, okay, yeah. So that's when she returned it all. So she was reviewing for 2 hours of time. Turns the laptop, phenomenal. On August 26th hours, I heard loud yelling from the hallways. Upon further investigating, I realized it was coming from the briefing room. The briefing room was occupied by inmate Boone and James Owens. Due to the loud disturbance, I entered the room and informed inmate Boone and Owens that they were causing a disturbance. Owens informed me that everything was good, and they had a little disagreement. After inmate Boone's interview meeting, I spoke with her about retrieving a grievance form. Par for the course. If you are the corrections officer that comes in after that and is like, hang on, Ms. Boone, do you want another grievance form? I bet she's filling out 20 of those things. Inmate Boone informed me that she did not need a grievance form. So this was the little kerfuffle that I think people were referring to. Refusing breakfast, reviewing materials. Boone has utilized laptops, so more laptop use. Interview the physical evidence that she conducted. Look, here's the thing. People are reading into this. Ian, do we dispel the notion that every conversation between attorney and client is peaceful and amicable?
Oh, God. I've had clients threaten to kill me. I've had clients. I had a guy who threatened to kill me while we were like mid-trial. And I was like, okay, are you good now? And he's like, yeah. I was like, okay, because we still got like half the trial to go through. And he's like, no, I didn't mean it. And I was like, I know you didn't. Or, if I thought you meant it, we'd be done. But he's like, you don't think the guard heard it, did you? And I was like, I'm pretty sure he did. He's just
Yeah.
not coming in here to arrest you as a favor to me.
Yeah.
So
We were screaming. He heard it.
yeah. And so he's like, so what do we do now? I'm like, we run the rest of the trial. I still think we have a good case. And we won. And we got out, you know, and I ran into him a little bit later because he actually came into my office and was like, I really wanted to say sorry. Like I lost my temper in there. I thought we were going to lose. And I was like, no, it's good. Like it happens. He's like, anyway, I brought you chocolates. And he hands over the chocolates and he says, and just because I know you deal with some bad people, I got the ones that are wrapped in plastic. So you know I didn't fuck with them. And I was like, yes, you
You rock.
I was like, you understand.
You get it, man. This is what Laura coming in. Don't forget, Rob threatened a client with a fork. I did. Like the client's like, what if I get up and lie on the sand like he did? I will stab you in the leg with this fork. Don't talk like that. Stop. Yeah, no, look, here's the thing. Their lives are on the line. The most important things in the world to them are on the line. They are at their wits' end. They are at their just breaking point. So I extend a great deal of latitude to things that are said to me in frustration.
I mean,
And
you get clients with
a whole
mental
lot
health
said back, too.
issues.
Yeah.
You get clients with, you know, because people with mental health issues get arrested more than your average bear. And sometimes it's for stupid shit. And they also have kids. So Rob gets them too.
Mhm.
Yeah. Yep.
There's my managing partner did a podcast once, which was, I think, one of the most widely listened to podcasts that he's ever been a part of. And what was the title of it? It was My Husband's a Narcissist. My wife is a husband's a narcissist. My wife is I can't remember if it was abuser. It was something, but it was when marriages go south and relationships sour. You see some of the worst conduct out of people that you would ever imagine. So,
I mean, the number
yeah.
of files I've had that have been like, one of the things that is the worst is you get an allegation of like abuse of children that comes right after a divorce. And it's like, because sometimes it's legit,
Really
right?
hard.
And sometimes it's not legit. And you're just like, I don't know what we're looking at here. I don't know what the, you know, and I mean, it depends. Sometimes there's little clues, like when the divorce is filed immediately after the reveal, like daughter said bad things happened, you know, and she said this on June 10th. Paperwork for divorce was filed June 11th. I'm like,
but there's also worlds where
it.
that's completely consistent. Like there's worlds where that actually happens and
I
it's
mean,
legitimate.
no, but that one is actually suggests legitimate because that suggests somebody who walked out the door and like immediately went to their family lawyer and is like, divorce this man.
Yeah,
like
I mean,
today.
it's wild. So that's why I'm really cautious when I see reports of that kind of stuff. I am very cautious because very rarely is the story that you see 100% of the story, and it's very careful. You have to approach these things remarkably carefully because something might appear from the outside to be 180 degrees different than what it is.
I also get nervous when it comes just as like the custody dispute starts to heat up. That and the thing is sometimes it's still true, but you'll have a guy in there saying it never happened, and you're like, where are we?
Yep. That's also why we need to train judges. We need judges from the domestic relations bench because you get judges that see it every day and that can actually understand, who have seen it enough to know. So it's really tough, because I had a case with the chief judge in Fairfax, not Judge Ascarati, but before Judge Ascarati, Judge White, where in the judge's ruling, the judge basically said, it's very clear to me that you've both used allegations not for a proper purpose. Like, you have implemented you've implemented the state system, you've implemented the state and prosecutorial authority to gain advantage in litigation. The judge said both of you did it. And the thing is, both attorneys knew they did it. But a judge that has seen enough of it to be able to see through the BS is a really big asset to actually getting the right result in these cases. So, but I did want to go over this briefly, because here's the thing. Why is it that we've been talking so much about the use of battered spouse defense, and why it's going to be not the easiest thing in the world to do? So what I ended up doing,
you want the short answer? It's just juries.
It's juries, but you have to admit a whole lot. So battered spouse, and I actually pulled two of the relevant authorities in Florida on the issue, because I wanted to bring it up. There's a certain element of Florida jurisprudence that makes this a pretty big concern for someone like Sarah Boone. So first, we begin with this initial premise of State v. Hickson. So the question is, one of the questions that was asked in this case was whether they could use battered spouse defense at all, and whether or not someone waived a privilege by having a therapist get up there and talk about interactions between husband and spouse, or husband and wife, or vice versa. So the question asked in this case was, is the defendant's constitutional privilege against testimony examination waived when the defense psychologist testifies about circumstances giving rise to the alleged battered spouse syndrome? All right. So they rephrase the question instead when they're reviewing it on appeal, and they basically say, what can an expert testify to when a defendant wants to rely on battered spouse syndrome? So what is this expert that Sarah Boone is going to put on the stand? What are they going to testify to? Why is that going to be relevant for the jury? It's very important to know what this expert can testify to. So the holding in this case was that an expert could generally describe the syndrome and the characteristics of a person suffering from the syndrome, and can express an opinion, this part's relevant, in response to hypothetical questions predicated on facts in evidence, but cannot give an opinion on interview of the defendant as to the applicability of the syndrome to that defendant, unless blah, blah, blah. Here's where this little here, in response to hypothetical questions, is going to become fairly relevant in Sarah Boone's case. And in order to kind of fully explain that, we have to go to this next case, which is the Wien case, Wien v. State. 99 opinion. So
Look at
there
you
was
doing
a rule.
doing the homework.
I was looking at it. I was very curious, because I don't various states have adopted the battered spouse defense that you're allowed to use. But Florida's is more nuanced than other ones that I've seen. So battered spouse defense is a offshoot of self-defense, right? It's a delayed self-defense, where the imminence factor is something that is subject to dispute, but you still have to prove all of the elements of self-defense in order to prevail on the battered spouse defense. Now, if you recall from self-defense, you actually have to acknowledge and admit to committing the act that led to this person's death, right? Self-defense, you have to actually acknowledge, I pulled the trigger, or I did the actions that caused this death. You don't get it
Not
both
necessarily.
ways. Give me the example where you don't have to acknowledge that.
Person doesn't testify. So the accused doesn't testify. Their identity is an issue.
True. Identity is an issue.
You've got
you can still
somebody in a
preserve
dark alley got into a fight with somebody else, and there was a stabbing. And you could have identity as an issue. We don't know who the person was, but you could also have an independent witness who says, I didn't see who it was, but I did see that the guy who got stabbed and killed was the first person to pull a knife. He was trying to rob the guy. He said, I'm going to kill you. And so you could have a jury facing two questions. One, is the guy who was in that confrontation actually the person? And two, it could be self-defense because there's evidence to establish it.
I think in the U.S. you run into problems with that. I think there's some states that don't let you play that both ways. And
I
think
mean, I
that's-
suspect there probably is because there's states that have all sorts of rules, but I mean, that's not really applicable in this case.
It's not.
The thing
Not
is,
in this case.
This case, the defense has the lovely spot of already knowing that they're not going to be able to argue the facts, like the like, did she do it? Because that's on video.
It's on video. Like she records herself on video talking to him in the suitcase.
So there's just no way that I see that they're going to say it wasn't her killing him right there.
And
So-
here's where I think Florida's nuance on this one is going to be even more problematic for her. We've already talked about some of the nuance that you've got where if you are making the claim that you are the individual who has suffered from this affliction, or suffered from the multiple batteries that led to this syndrome, then your past history of conduct comes at issue as well. If you are an aggressor in these prior interactions, and there are instances where she was, so her history comes before the jury as well. You can't open part of the door and not expect all of it to get kicked wide open, and it will. So that's risk number one. But in reading this case law, I actually found a second risk that I thought was even more interesting to me. So the chat has already pointed out, interestingly, that yes, the reference that you're seeing here, Bobbitt, State v. Bobbitt, is in fact to Lorena Bobbitt. Yes.
Oh, absolutely.
That is the State v. Bobbitt case. Lorena Bobbitt, who just deprived
choppy
chop of yep, that was that one. And if you are too young to remember that case, stop watching maybe. I mean, no.
Ooh, can I describe it? Can I describe it?
I want to see how clever you get with the English language in describing this. Please do so without doing it inappropriately.
Without getting demonetized. Okay.
Yeah. Let's see how you can do it.
So the initial reports, because there's actually two stages of reporting. The initial reports was woman goes crazy, and while guy is sleeping, decides to give a little haircut to the meat and two veg, such that it's just the two veg that's left.
Not bad.
She then drives down the highway with sausage in hand and disperses sausage to a random port of the road. So later what was discovered was that, they recovered the sausage and were able to stitch it back, and he got a porn career apparently. So
that part I didn't remember.
Yeah, he did porn apparently. But what later came out was that she was saying that he was tremendously abusive.
Yeah.
And that this was kind of a response to that. And so initially all of the stories were like, hey, she's this crazy person who stole the key bits and ran off with them and put them on, sent them onto the road. But what it turned out, or seems to be, is that there were serious issues of abuse, and it might have been connected to that. So it was a much more complicated story than was initially revealed. And
so here's where the case law becomes relevant. This is a terrible fact I never knew I needed to know. A bobbit worm is named after her. And you know, Bop It wins. Bop It wins. Bop It 100% wins. It wasn't me. No, it was not you, Bop It. It was Bop It. It was not you, Bop It the dog. It was Lorena Bobbitt the person. So the interesting thing on the case law is this case gets appealed because there was an instruction given that essentially imposed a duty of retreat. Remember how I said that at the very beginning that the battered spouse syndrome is actually a way of explaining self-defense.
I went on a rant about this, and initially I pissed a lot of people off, and then I think most of them came around.
It's very complicated to explain the foundations of this, and
I don't
go
like
ahead.
the medicalization of it, and
It's difficult.
my take on it is really that really we should just understand that self-defense can be complicated, and that sometimes there's good reasons why people might not run away. And the problem is that by making it into a notion that it's that it's this medical concern and that it's this like psychological problem, that then it provides a barrier to use of it, because then you need an actual diagnosis. When I don't actually think it's a mental illness, I think it's a rational response to extremely shitty situations, and that that the whole thing about saying that it's a mental health thing is a problem. So
Can I push back on that a little bit? So
you can.
One of the challenges I have with that is the court is the gatekeeper to, and I mean, honestly, these trials, there should be a gatekeeper to the presentation of evidence where you're not putting on anything and everything that might confuse a jury. There are cases where, let me put it this way, if every single human in the world could put on any number of, I mean, look at the factual scope of information that you would claim to be relevant if you didn't put a barrier in front of the use of that. Justifications that people would try to use to justify conduct that's clearly criminal, that is not justifiable, but is asking for jury nullification.
I'm okay with the notion that like we can dispense with this without creating what I think, frankly, is probably a fake mental health condition. I don't think it's a mental health condition. I think it is that we've all sort of agreed that this effed up stuff happens.
Yep.
And that the self-defense law needs to be able to handle it.
That's not a bad way of looking at it. I would still say that you have to, in order to assert that defense, similar with asserting self-defense, you have to give notice to the other side, and you have to have some factual affirmative evidence that you can prove to demonstrate the elements before the jury gets to see anything about it.
I would have no problem with saying, listen, this is like going to be hard to prove because you have to establish, you know, something that is fairly difficult to establish. The whole aspect of, you know, under your circumstances, running away was not like a reasonable option. But I think there are circumstances where running away is not a reasonable option. And I gave an example that I think is entirely non-medicalized that makes sense. So let's say somebody kidnaps you and they lock you in a cage. And they say,
wait,
have a good night, Wesley. I'll probably kill you in the morning.
I saw that example. Can you pause for 2 seconds? Because this becomes relevant with the case. Do not forget this hypothetical. Do not, because this is it's good with this case. And this actually explains. Did you go over Florida law on this yet?
A little bit, yeah.
With how the Castle Doctrine was modified a little bit.
Yep.
Okay, this is the case that did it. So prior to, under the case of state, am I repeating stuff? Did you already go over this case?
No.
Okay.
I haven't covered it. I just read some of this stuff.
Yeah. So State v. Boppitt, right? There was a part of the charge was that the Castle Doctrine did not apply in this. You basically could not claim this. You could not claim, where was it? There was a duty retreat. Yeah, there it is. Hang on. Questions rephrased. Should the law impose a duty to retreat from the residence before defendant may justifiably resort to deadly force in self-defense against a co-occupant if that force is necessary to prevent death or great bodily harm? So is there an obligation to retreat? Okay. If you co-reside with this individual, what does the state do? What does the Supreme Court of Florida do? Well, they don't really answer the damn question. They really don't. The state of Florida does the following. And they do so in language that they like to say is very absolute. In conclusion, we hold that there is no duty to retreat from the residence before resorting to deadly force against a co-occupant or invitee if necessary to prevent death or great bodily harm. Okay, so you're reading that and you're going, all right, there's no duty to retreat. I don't have to make any efforts to remove myself from this situation before I can use death or bodily harm in defense of something that I have, by nature of this syndrome, believed to be imminent threat. Okay, so I don't have a duty to retreat. Great. Way to go, Florida. Comma. Oh, shit. Although there is a duty to retreat within the residence to the extent reasonably possible. So what the hell does that mean? I think that's my question. What the hell does that mean? How are we supposed to interpret that if you're looking at this specific situation of inter-partner violence? Where does that limited duty to retreat, if there's an extent reasonably possible, that is making this area of law so much grayer than it was. So now the prosecution, if the defense is
And
raised,
that's partially because they were citing State versus Gray.
yeah, I see what you did there. It was very good. Very good. Gray area. Part of the problem that Sarah Boone runs into, and that any person in Florida who's putting on this defense runs into, is the state under this rule now gets to present evidence of your opportunity to retreat within the residence and ask you questions and that's why I brought up that first case, the State v. Hickson. What can they ask this expert? Well, the expert gets posed hypotheticals based on the facts. So the expert testifies that there was clearly battered wife syndrome or battered spouse syndrome. And I'm sorry for keep calling it battered wife syndrome. That's how it was called for years and years and years and years. And it's the case law that's just stuck in my head. So someone that says battered spouse syndrome has a therapist that gets up and testifies to the facts and says, this is completely consistent with battered spouse syndrome. It's clear this person felt imminence in the threat of actual physical bodily harm, and that they felt that they could not retreat in that moment and they had to use bodily harm to protect themselves, right? So you've satisfied all the elements via that first direct examination. Well, now in cross-examination, the prosecutor gets to start laying out every opportunity this person had to retreat within the home or to alleviate themselves from this possible violence that they had been subjected to. And in the case of Sarah Boone, if I'm asking you guys a reasonable question, your significant other is locked in a suitcase.
I mean, I think the main thing they're going to run into as a serious problem
Is the prior act,
is no, not even that. Not even that.
the interviews?
I think the big thing is just going to be they need for the person to be believing, like the jury to be believing that she looks like a victim, and
acts
that's
like one.
really.
And I hate to say it that way. I'm sorry for phrasing it that way.
But she's not going to look like a victim. That's going to be the big problem. That's going to be huge. Even if this guy was like, I'm going to kill you tomorrow, right? And she did this to whatever. The video is going to destroy her because nobody's going to think she doesn't look like the battered, spouse syndrome poster child.
It's not, and it's not even the video of her laughing in the suitcase. Because if I'm viewing this case, I think there's a way I can argue that, where it's not the laughing, the interviews after the fact.
I mean, I just don't see it, right? I get that they've got to run the case, because the sad truth of being a criminal defense lawyer is that there's plenty of cases that you will get where you start out and you are just from the get-go effed. And the problem is that if the penalty is serious enough that that it's just not, there's not really a room for anything other than you run it, right? So, I mean, she's going to go to jail for life if convicted. She's going to die in a prison cell if she's convicted. So, like, they got to run it, right? So if your only defense is garbage, you run the garbage.
Yeah.
Like, that's it.
And you and I have speculated as to the screaming matches that existed in the jail, in the jail meeting rooms. We've speculated as to that, and I think that we can't be really that far off. Counsel has been trying to convey to her all the risks in running such a defense rather than discussing with the state a reasonable plea. And she doesn't want to plea. It's very clear. She doesn't want to plea. She doesn't want to talk plea. She doesn't want anything to do with the plea. And she's had learned attorneys approach her and say, look, here's the problem with this defense. This defense is not going to prevail. And she can't process that. It is completely foreign to her that somehow this wouldn't work. And why isn't someone believing me? And it's not that they don't, I mean, they're just telling you how it is. They're not going to, give you candy canes and fairy tales and tell you that we're totally going to win. However, I do think that she's on the right track with this particular attorney, because he gave an interview afterwards, or after that hearing. So let's listen to some of it.
Excuse me? Sarah, excuse me?
Really quiet, isn't it? Let's gain this up.
It's real quiet.
Yeah, let's gain it up.
Sarah Boone needed a lawyer. And I can't imagine our system. The case is an aberration. Okay? Just a gap in the system that hardly ever happens. On the federal level, on the state level, everybody charged with a crime is entitled to counsel. Everybody. Never, unless the defendant waives their right and wants to represent themselves, which is rare and foolish. But I understand the judge's ruling. We respect the judge's ruling. But that left Sarah in a position where she's standing in a courtroom accused of murder without a lawyer. I can't think of any other time that you would need one than in that scenario. So once that decision was made by the court, Sarah put an ad out. Somehow it got on court TV. I watch a lot of YouTube, true crime. I saw.
Sorry, Mr. Owens. Hang on. Mr. Owens, I'm sorry if you're watching this. Sorry, but also not sorry. I appreciate everything you're doing. Good job.
I'm not sorry.
Yeah, he's doing good.
I appreciate what he's doing.
I do too. He
came on a shit file and he's doing what he can.
Do we need to revisit the ad? We need to revisit the ad. We need to revisit the ad. We're revisiting the ad.
Fine, we can revisit the ad.
The ad is too good. What are you talking about? You're pouting about revisiting the ad. This thing is gold. This is the ad he saw. Sarah Boone's letter worked.
I was just stunned that this advertisement worked. So
Sarah Boone's letter worked. So, yeah. So the attorney saw the ad, and thus we have this press conference.
I didn't immediately act on it. I waited 3 or 4 weeks thinking that one of the members of the defense bar here in Orlando would pick up the torch. 3 or 4 weeks went by. It did not happen.
Oh, fuck you, buddy.
The case down here in
Can we
Hillsborough,
pause?
Tampa, that I had.
He was waiting for someone else to pick up the case. I know it's not the greatest look.
I mean, I'm just gonna give that a big old heap of fu because it is not the job of the defense bar to work for free for crazy people. Sorry, no. It's lovely if somebody does, but you can't just expect that the
Someone jump in.
yeah. I'm like, come on, right?
Yeah.
So
I
don't like that at all. I'm just like, no, sorry. Like, that's throwing a little bit of shade at the other lawyers who didn't step up. And I'm like, no, it's great that you did, sir. I really appreciate that you did. Fan freaking tastic, right? But no, like, and the thing is she's a bar complaint magnet, right?
Yeah. I mean, you know what's going to happen. Now, I do want you to process this. This guy's 6 hours away. So he is quite a distance away. So for him to pick up when he does have a full practice is a difficult. I just don't like him throwing everyone else under the bus.
Yeah, it's the everyone else under the bus that bothers me.
Yeah.
So I got no issue with him taking on the file. Like, good for him.
And no, he's not crapping on the prior court appointed counsel. He's not crapping on anybody that was either conflicted out, fired, or couldn't work with her. What he's doing is that he's basically casting aside, everyone else saying, come on, guys, isn't someone going to pick this up? And no one did. And he's like, fine, I'll do it.
He's throwing shade at the lawyers who didn't step up to, to run this for free. And I'm like,
I'm not picking up this case.
Yeah, I would not be. I wouldn't touch this one, and I'm pretty. I'm pretty much a sort of bleeding heart crusader there. So, yeah. No, that kind of annoyed me.
Wait, I keep seeing this question fly by. And Apple Silver, here's the thing. I don't think in any jurisdiction it's not that the victim isn't the person who has the burden of proof. The prosecution, the state does, the Commonwealth does, the Crown does. The independent third party is the prosecutor trying to hold this person to account for the crime has the burden of proof. We can actually put the victim on, like they can put the victim on and have them testify against their will if they need to. That's the state has the burden in that. So let's see. Maybe he'll gain back some points.
Had to come down for. So I wrote her a letter about a week before that. And she had a third party, a girl from Minnesota, that reached out to me, I think first just to see if I was legitimate. They said, see if I would, I think catfishing is what they thought I was doing. Some fraud. I think once the third party realized that I was genuine, then Sarah called me. We talked on the phone a couple of times, and I said, hey, I'm coming down that Wednesday.
Let me pause. Maybe it'll catch up. Stop buffering.
For that court case in Tampa. Why don't I just come down Monday, which I did. I got done with court, I think, Monday at noon.
Stupid internet.
I drove down 6 hours, spent the night, got up the next morning. I think that was on the 20th.
This is starting to turn into then I tied an onion on my belt story.
But yeah, let's see.
To then communicate with the defendant. Actually, the rules say you got to
For
do
breakfast, I had 2 eggs and cereal.
Why is this?
We couldn't reach an agreement.
Oh, I think they're talking about a plea deal.
well, they let me meet with them. So the three of us met. This was, I think, the 21st, like it's set from 7 to 8:30. We met for about an hour and a half. And, you know, at that point, we couldn't reach an agreement. And then I wasn't ready to represent her at that point. I immediately told the prosecutor that there was an impasse, there was no agreement, that I was not going to be representing her. I got in the car and drove back home, got home about 4. I had court the next morning at 8:30. I was.
Why is he
done with
telling
the
us all the
case.
things about
Did
their
the best I could.
communication?
I want to say 2 nights later, my wife and I were home.
I don't
and Sarah
know.
called, and we talked
It's inappropriate.
This is
again. Of course, I was still.
not okay.
It's inappropriate for him to be telling the story of how they
Got retained. This is not a love
Yeah.
story.
Yeah, you don't get to tell your meet cute with your client.
It's a whole lot of talky about a
Yeah,
whole
when
lot
it
of
should be
talky.
shutting the hell up, yuppie.
Still thinking about it, what to do, and but I
He just verbatim said what his client said in a protected communication, didn't he?
He did.
told Sarah I was not committed to doing it. That was
He just told the press what he told his client in a protected communication, didn't he?
Yep.
on like the 23rd. Well, then that third party called a day or two later, and really nice lady that I really respect. We've developed a relationship, and she asked me if I would go one more time. So I flew back down.
Stop
Met again
talking.
a couple of times. I can't remember the dates now, 25th and the 26th. But
Oh, that was the screaming match. That was the screaming match.
Why is he talking?
I don't know. I don't understand.
Sir, your mouth parts are moving when maybe your brain should be telling them not to.
This is the
Move
is
the
very
brain, not the
confused.
mouth parts.
confusing to me. I'm so thrown right now. I didn't expect this to be happening because I saw motions being filed and I saw argument. I was expecting something different of this press conference, and when I saw the video and it said 11 minutes long, I was like, "There's no way it's 11 minutes of him talking. That wouldn't be smart prior to trial when you're the defense." I'm afraid this might get worse. The chat is making me more afraid that this is going to get worse.
Why talkie, sir?
Lucy Fair, privilege attaches before you're retained. Just to
Privilege
let you know.
attaches as soon as somebody reaches out to you.
Yep.
The
As
whole
soon-
thing you see on Breaking Bad about like give me $1 or whatever, or
No,
give me
that's
a
bullshit.
quarter.
No.
That is bullshit. That is
privilege.
know.
Privilege attaches the second that someone reaches out to our firm. Like if someone even when they're talking to our intake team, like who are not lawyers because they're affiliated with our firm, privilege attaches.
Let's give an example here. So for a while, there was a scam going around. And the scam was you'd go to a web page and it would come up with a big banner and it would say, "We have detected child porn on your computer."
God, man, you hadn't say the two words next to each other.
I checked that we're past 2 hours. They're not paying attention. And so what they do is, and then it says, you need to pay a fine in order to, in order to avoid prosecution. And the thing is if they find that sort of thing on your computer, like the actual police, it's not like pay a small fine in order to make it go away. You're going to be in a lot of trouble. Now, the thing is people freak out when they see that because of course they freak out when they see that. So they contact a lawyer and I get to explain, yeah, it's just a scam. Like you can ignore it. Because typically what I'd get is like kindly old dude who is like, I don't have anything like this, but maybe somebody downloaded, maybe somebody like, I don't know computers, right? And so it's like, okay, so, you don't need to hire me because nothing is really happening. The thing is that if you actually posted online, if I posted so-and-so came to see me to ask me or got me on the phone to ask me about being concerned about, bad pictures possibly being on their computer, I could explain the whole story about it, and it would ruin their life, right? Even though they haven't actually done anything wrong, they're just sufficiently lacking in cleverness that they don't understand that they're being taken for a scam. So yeah, that's
Privilege attaches. Privilege attaches the second that someone reaches out to you and there's the contemplation that they are seeking from you legal advice. And you engage them in a discussion where that is the understanding of the person that's speaking to you. So when Sarah Boone speaks to me, if I have a reasonable understanding that the person in front of me is asking me for advice or coming to me in the course of seeking to obtain my representation, that what they are communicating to me in that endeavor, in that effort, is privileged. I cannot divulge it.
Yep.
So
I mean,
for
the other
example,
one, somebody comes up to you and is like, "Hey, I'm thinking of divorcing my wife."
Yeah. Or hey, hear about this. Hey, Rob, you're a lawyer, right? Rob, you're a lawyer. I'm in a situation right now, and I could use your help. Even something as innocuous as that. And let's say the next words out of their mouth are, "So I hit my wife the other day," right?
Yeah, that's a bad thing.
Those words were said in the context of that person approaching me in my capacity as a lawyer, seeking my advice in the capacity as a lawyer, which means that if a cop were to sit me down for an interview and say, "Mr. Morton, what did this person say to you?" I would say, "Pound sand."
Yeah. What did they say to you? They wanted me to communicate to you, go F yourself with a shovel.
Yes. And they can't do anything.
And like not the easy end of the shovel, the other end.
Now the caveat is
the shovel end.
No. The caveat is that the privilege belongs to the client. That's something I saw questions about. And I want to clear this up. I've kind of addressed this before. Doesn't that technically void all this client privilege? No. The privilege belongs to the client. The attorney cannot waive the client's privilege for the client. Only the client can.
Also, the client can waive the privilege against the wishes of the lawyer.
Correct.
Because this comes up sometimes where you've got like a lawyer who's behaved badly, and you'll get a lawyer saying, "Oh, well, this is privileged," and the client's like, "Yeah, except I'm trying to throw you under the bus," because usually it's because that's where the lawyer belongs. So you get situations where the lawyer's like, well, it's privileged, and the it doesn't work that way.
Here's this one I've raised. We've already talked about this. It's when he's not a client. It doesn't matter. That does not. I'm telling you emphatically, 100%. That does not matter.
Yeah.
Kate asked the question. This is not basically saying I talked to her and had reservations about representing her. Here, I want to bring you back
which
to
is an incredibly bad thing to say about your client.
And that's the thing. We talked about this when the Fonnie Willis, Nathan Wade, that thing was going on, right? And the lawyer that was there was basically saying anything's communicated to me by this person is privileged. And we were kind of going back and forth on that. We said, no, not really. If they're coming to you and saying, as a friend, they're saying, "Let's have a beer," or if they're saying, "Did you like that sports game?" No, that's not privileged. But if they're talking to you about their case in any capacity, then that is privileged communication. James, was she better off alone? No, emphatically no, she was not. No. And then this one was a question I was very curious about. Could she have given him permission to talk to drum up support for her? It's possible. Anything's possible. I don't know. I'm now cautiously curious as to what's going to happen in the next 5 minutes because the chat is telling me it gets worse.
How does it get worse?
I don't know how, But we're going to
Like,
find
does
out.
he physically attack the reporter, or?
Oh, Allie, people still do this. People used to call divorce attorneys prior to their spouse in order to stop them from being. They still do.
This is why, why divorce lawyers generally charge a consultation fee.
Yep,
Because, yeah,
they still do. I get called to be conflicted out, which is like it's like something about that's a little bit of a badge of pride. There's also like when I will meet with clients.
I guess it
they're
would really suck
concerned-
if you never got called to be conflicted out.
Conflicted out. Yeah, no one's afraid of you. No one's concerned about you. No, but there are times when I'll have a client come to me and we're concerned about the tactics by the other side, and I'll tell that client, I said, these are the 3 lawyers I want you to meet with. They charge $500 for a consultation. You're going to pay the consultation because if your spouse gets this lawyer, your case is going to be a nightmare. And I'll tell you, it's.
Couldn't do that here. If you are found to be intentionally conflicting people out,
I don't say entitled to it intentionally. I
Oh,
don't
it
tell them
gets-
to do it that way.
it gets
I
you
just-
hammered if caught on that.
I
So-
just suggest that there are attorneys that have a certain reputation, and that it would be rather expensive for the client if said attorneys were employed by their spouse.
The unethical sort of attorneys, I'm taking it. You've got.
In my
I know
list,
that
there's
lawyers
there's
who
probably
just love
Go
to
ahead.
run everything up.
that's in my list of about 5. I would say 3 of them are completely straight shooters. They are just like dogs in the courtroom. Like they will run everything. And the other 2 are of the variety you were describing.
Yeah, I'm not a big fan of when you get lawyers who are just like, I'm gonna make you like every step is gonna be just misery.
Miserable for the sake of misery. Anyways, let's keep listening.
Both meetings went well. And you got to understand, Sarah's been through 8 lawyers, so there's some trust issues. And on both sides, I'm concerned, is she going to try to fire me, or we're going to have problems the same way, as you can imagine. But
Why?
I like her, she likes me, we communicate well. I think we're both.
It's a whole lot of more words in like 5 seconds. I'm kind of glad for the spinning wheel because
on
I'm
the same
processing.
page. And I spoke to my family, my wife, my daughter.
Hang on, let me try this. Can I open the video in the new tab? Nah.
Daughter Sarah about it. Sarah's thinking about law school, so
Oh, we're going through life story now.
I got their blessing. I have, some colleagues that I practice law with, a law group. They're in Milton, and obviously it's going to take some staff to pull something like this off, especially knowing that the judge. I was in hopes he was going to continue it and give me 2 or 3 months. He did not. So we've got about 30 days. So I'm going to have some help from the staff, but
This guy makes me want to drink.
I'm trying to assemble a team right now. I've got a couple of friends that are lawyers that have
Possibly poison.
indicated they're going to help me. And
Oh, baby, we breathing. We're going low quality. We are deep breathing. We are wine. We need wine. We need so much wine.
what are friends for?
Are you doing it pro bono?
I've been retained. I'm not doing it pro bono.
Who's paying for it?
Sarah owes me. Sarah owes me.
Bro, didn't you just tell the court you were doing it pro bono?
Well, I'm not an expert, but I don't know if we're going to be able to do that because we're time crunched now. As you know, I think y'all understand the rule now. We've only got till the 9th, which was today, the 3rd. We've got 6 days. So I'm going to try to pay for Dr. Julie Harper to fly down here later this week. She's actually from my area. The 2 experts that I had asked for, well, there's a 3rd one, but 2 of them are from my area. Dr. Harper's from Okaloosa County and Dr. Berkman's from Escambia County, but I've been in communication with Dr. Harper. I think I'm going to get her to fly down here later this week to meet with Sarah several times. Hopefully,
Guys, I know the audio sucks. I have this gained up 600% from the original audio, and the original audio is mono. It is not stereo. So there's only one speaker that you have that's actually playing the audio from this interview. I am trying. I really am. I can turn us down. Let me do that. I'll turn our volume down. Here, we'll turn our volume down so that you can. There. Ian and I are now both turned down. Hopefully that helps.
at the end of those meetings, like I said, she's already met with her, but it was 2 years ago. She met with her 5 or 6 times. Hopefully, she's going to agree with me that she does suffer from battered spouse syndrome. And so then if she's able to give me that opinion.
He just tendered an expert that he doesn't know has the opinion that agrees with them. Oh, shit.
Oh. Oh, wow. Oh, wow.
You just notified the state that you're intending to use battered spouse syndrome as a defense. And you don't know if you have an expert that's going to agree with you.
Opinion by the end of this week. My intent is to file the notice with the court and the clerk of our intent to rely on that defense, and then we go from there. That's really all I can say. It's up to Dr. Harper, not me.
So you've got 6 days to do that. Now, barring a Matlock miracle and that doesn't occur, what is your other, I guess, plan of action?
Well, Sarah's been sitting in jail for a while. She's looking for her day in court, and we all want justice to be served. I'm a criminal defense lawyer. I've been doing it a long time. The state has the burden of proof. They have to prove their case. I know there's some strong evidence in the case, but there are some explanations.
It does get worse. I didn't think it would. This is a press conference. Maybe he just didn't sleep the night before. I don't know.
I'd rather not get into my other potential defenses, but we do have some
It's a little late now to unfuck this.
beyond a reasonable doubt.
Sir, that's not a defense. They have to prove this beyond a reasonable doubt. That's not a defense.
I mean, it kind of is.
My defense is that the state has to meet their burden. Yeah, that's fair. When I phrase it like that, it makes more sense.
I mean, I've had a lot of
That's all I
pretrial
really
conferences
say.
where they're like, so what's
just like
your
any
argument? And I'm like, my argument is he's got to prove it.
Hang on. Ian, we're going to take bets on whether this statement out of his mouth is true or not. He makes the statement. I'm going to be back about 5 seconds.
Some defenses. They've got to convince the jury beyond a reasonable doubt. That's all I really want to say. Just like any.
But can you give me your best narrator voice?
No.
Was that really all he wanted to say?
I see we are at 8 minutes and 39 seconds out of an 11-minute, 22-second video. So unless the rest of it is like a dance number, we're and that really is the best way he could spend that remaining time is a dance number.
Odds on getting a dance number, chat, because I'm feeling like it's not very high. But wait, there's more. Apparently, chat's
Any other lawyer facing a trial on a criminal case, the state has the burden. We're going to test the state's evidence, and then we've got potentially a case to put on. But we'll see. We'll see what happens into this week. It'll be interesting to see if we can utilize, because I do believe she meets the criteria just from everything that I have viewed in terms of Mr. Torres's prior arrest. I did want to say something else, but I want to say something, but I'll wait for you. If you
We
got
gotta
questions.
move downstairs.
Okay.
Or, I mean, we can just wrap it up.
We can just wrap it up.
I did want to say this. The Torres brothers.
The reporters are like,
violence
we're done here. And he's like, no, I got more bullshit.
oh baby.
This is like the ref is like, I'm calling the match, like I'm calling the fight. And he's like, no, I need to get hit more in this boxing match. I have not been punched enough. And so let me get back in there.
Did you see the sweeping statement? Did you hear the sweeping statement?
I missed
The
sweeping
Torres
statement.
brothers were violent against women.
Oh, that's
Just- That was how this started. And I paused because there's only one direction this goes.
I was gonna try to sing some One Direction, and then I don't actually know any of their songs, so yeah.
I'll say that again. The Torres brothers,
Oh,
George and Farrell Torres, are violent towards their women. Farrell Torres is George's brother. Are y'all aware of this? He was arrested in May in Seminole County for killing his girlfriend, the mother of his children. He stabbed her to death. I've got the file right here. He called 911. Eventually, the 911 operator got around to, where is the weapon? Where is the knife? It was still in her head. I don't know. Sarah's told me about the family, the dysfunction. I seriously doubt that's going to be admissible in my trial.
no shit.
Yeah,
What
but
the fuck was that?
this is completely inadmissible at trial. However, I'm just gonna put this out in the public because yeah.
What the fuck was that? I honestly think that, I mean, there's certain restrictions on what we can say publicly. What the shit did I just listen to? Talk about the brother without any connection, and now you're referring back to. I don't know
Wow.
what to say.
Where's my goat?
What the fuck just happened?
But
I don't know.
there's two sides to every story. And Sarah's got a story to tell. I think she's been mistreated to some degree. It's difficult to represent yourself. I wish you could just
Did he just say
you had a
mistreated to
daughter
some
that was in a
degree?
situation where she's
Yes.
representing herself, or maybe
Dude.
a sister. Just for 10 minutes,
You-
just think about
You're
her
running a
situation.
battered spouse defense.
Hang on. So, but the sentence that immediately follows this guy's brother stabs someone in the head. and therefore he is the person that did it bad. He's now talking about how he wished that Sarah had a sister or like some family.
I see somebody saying code red. This is not code red. This is code brown.
This was a choice.
Yeah, she's back.
I mean, lots of things are choices.
She's the type
Um,
like most of us are.
She's back to, oh no. He's nope. He's not going to say it. He is not going to say it. He's not going to say backed into a corner and fights your way out or becomes, or just, he's not going to make some statement like that. Not in a self-defense case, not in a battered spouse case. He's not going to.
Are they going to come out swinging? That's what she's been doing.
That's
some
what
of
he
it
did.
is probably appropriate. Some of it has been inappropriate, but
And that's what he did too. Holy shit.
wow.
This is a battered spouse defense. Remember how we talked about how this is a self-defense case and how the use of force has to be an appropriate use of force in response, and that oh my God, that when you make the comment of, when you're backed into a corner, you know where it's coming, you know what's coming next. They're going to fight their way out, or they're going to swing, or they're going to punch, or they're going to hit something. It was that last part that I didn't see coming, where he says, and some of it's appropriate and some of it's not, in reference to his client's behavior when backed into a corner when she wishes to assert the battered spouse defense. And he doesn't know if he has a doctor that agrees with him, but he told the court he did, and intends to rely on the defense after talking in detail about his hesitation in taking the case, multiple dialogues with Sarah that we have seen in records that show that they were screaming matches. And Sarah Boone has promised to repay him for a trial that's taking place in 30 days.
He's never getting repaid.
This became 7 different layers of clusterfuck.
Here's the thing. Criminal law, any money you don't have on trial day,
You'd never
it's
get
money you don't have the day you die. Because
you're never getting.
There's just no universe where they pay you. So
Still, can he do more damage in 6 seconds? 12 seconds?
all she knew to do was to fight, and she's been fighting. She doesn't have to fight anymore. I'm going to do the fighting for her. So she feels good about it. I feel good about it. We want justice to be served. We feel like if we get a fair jury, that we got a good chance. That's all I'm saying. She's been fighting. She doesn't have to fight anymore. I'm going to do the. She's the type, like most of us are, they're going to come out swinging.
Hang on.
Just for 10 minutes, just think about her situation. She's backed into a corner, and she's the type, like most of us are, they're going to come out swinging. That's what she's been doing. Some of it is probably appropriate. Some of it has been inappropriate, but it's all she knew to do was to fight. And she's been fighting. She doesn't have to fight anymore. I'm going to do the fighting for her. So she feels good about it. I feel good about it. We want justice to be served. We feel like if we get a fair jury, that we got a good chance. That's all I'm saying. She feels good about it. I feel good about it.
Hang on.
Fight. Appropriate. Some of it has been inappropriate, but it's all she knew to do was to fight. And
There's my screen grab. That's all she needed to do was to fight. Oh my God. I had such high hopes. I really had high hopes. I had high hopes.
are we going to start singing?
I don't think so. I'm too depressed to sing.
Yeah. Well, the good news is I get to go shooting tomorrow and Sunday.
Yep. I will say, I will agree with you. That is great news, Ian. Great news.
That's the only good news I can get out of that interview because, yeah.
Here's the thing. Wait, hang on. Is it really that bad? Grand scheme of things,
I don't think he gave
no.
away anything that was
He didn't
super...
give away anything. There's nothing prejudicial about it. There's nothing really bad about it that he did. The cringing is the lawyer inside of me, just one, at all the communications that are being divulged and how inappropriate that just is. Yes, it's not damaging, but you don't do it. I'm not allowed to tell people if my client came into my office with a cup of coffee or the time they called me, or just, you don't say it.
And the thing is that sometimes it can be really hard to know what will absolutely curb stomp your client. Example, this was not my file. It was another lawyer like talking about confessions. And there was an interview, and there was one statement they made that the Crown used to absolutely destroy their case. That statement was, "Yes, I go to this school." Absent that, they would have had a very hard time establishing identity.
Tell me it was a, oh, yep. He admitted he was at the school.
It stitched everything together enough that the judge was willing to convict, because we have a lot of judge-only trials here. Whereas if he just kept his mouth shut, nope. I have seen people convicted based on saying where their job was, because it turns out their job is somewhere near the offense.
Mm-hmm.
And the thing is none of this, at the time of the interview. And sometimes that shit you say at the time is just like, okay, I didn't think it was going to be a big deal, but then it's a big deal, right? So, yeah.
Oh, yeah. Yeah. Just because I saw Lindsay's chat flying by, where was it? The stop sign. I did see that there was a stop sign right behind during that pause moment. So I did see that. But holy crap. Just we just saw that. The other thing is, recognize the case and the posture of the case that's been presented in the media and how it's been presented at that point in time. Just recognize that the public has viewed the videos, they've seen the cackle, they've seen the laugh, they've seen everything, right? So everyone who's been following this case in any regard, especially the media that you're talking to, have seen all of this leading up to this moment. Maybe in recognition of the coverage thus far, you choose your words a little more carefully, especially if you recognize that you are going to speak to the media. And maybe I vehemently kind of hate what he did there at the end, where he paused and said, I know you guys need to pack up, but I want to say one thing.
Rob, can I share some sadness?
You may.
So I'm looking at buying a new phone because this one is old as hell. It's a Pixel 3. They're on the Pixel 9 now. So they've got a feature of like trade in your phone. And they're like, we will give you -$20. It's not quite that bad, but it was just like, yeah, we will accept your phone and we will throw it in the bin, because that's about it. I also have to share something and ask a question.
Yes.
So on my way home from the range, I was wearing my range safety glasses because they're prescription, and I forgot to change into my regular glasses before I got into the car. And then my regular glasses were in the trunk. So I wasn't going to stop. And I stopped at a light, and somebody saw me, and they laughed at me. So I need to get chat's opinion as to whether or not this is mockable as an appearance.
Oh no. Yes, it is mockable as an appearance. Yes, you look like you were from, what was the movie that? Oh,
The
God.
Aviator.
No, it wasn't that. It wasn't that. The fake superheroes. Ben Stiller was in it. Oh no. Hang on.
Mystery Men.
Yep, you look like you're in Mystery Men. You 1000% look like that. Why did you buy those glasses? Oh, those are your shooting glasses. That makes sense.
They cost me $50. They are safety glasses and they are prescriptions. So that's why I bought them. That's it. They look absolutely idiotic.
It doesn't make it not mockable. That's the $50 does not make it not mockable.
It's just I stopped at the light and the people crossing sort of laughed at, like they looked over and they laughed and they elbowed the person next to them to look at me, and that person laughed, and I was like, oh, I get it. Like, this looks absolutely idiotic. But
I need 30 seconds. Tell people, so you're shooting a competition tomorrow, right?
Yes, I'm doing a 3-gun competition.
Tell people about that for a minute and a half.
Sure. I could also perhaps tell them about the latest video I've got out, but I'll talk about okay. So latest video I've got out is so there's a YouTuber who goes by Fudbusters, but he's also a lawyer and a gun designer. And so he is suing somebody who is Cody Wilson, who operates DefCAD. Cody Wilson is, by all accounts, a piece of trash. Cody Wilson is known for, well, amongst other things, he was convicted, or he pled guilty regarding allegations that he had slept with somebody underage. And the other thing is he runs a 3D printing gun page. And the one of the things people complain about is that he basically steals their designs and posts them himself. Mm-hmm. So lots of people dislike this guy, and they, what do you call it? They did a, Fudbuster, like he did a, he basically made a bunch of 3D printable gun designs and then waited for them to steal it. And they stole it. And then he turned around and proceeded to sue the out of them. So now I want to say, Concealing, it's not Fudbusters who has the allegation of, he's the YouTuber. The person who has the allegation of doing the unsavory things is the guy behind DefCAD, Cody Wilson. Cody Wilson, and I say allegation, but he pled guilty. It was to a lesser and included offense, but he still had to register as a sex offender. So, yeah. But the guy behind DefCAD is a piece of garbage, and he's getting sued for all the money. All the money. And I laugh at it because F that guy. So, yeah. The competition I'm going to go shoot is 3-gun, which means you use handgun, rifle, shotgun. And so I am going to suck because I'm just not that good. But yeah, I'm going to go run that, and some of the stages look really, really fun, but also really challenging. One of the things about 3-gun is that you you have to sort of plan out how you're going to go about things, because there's different targets. And so like some of the targets you can shoot with the shotgun. Some of the targets you have to shoot with the rifle, and some of the targets you have to shoot with the handgun. And sometimes it's a matter of you can use like 2 different guns for something. So it might be this target you can shoot with pistol or shotgun, or this target you can shoot with pistol or rifle, right? So somebody says difference between a rifle and a shotgun. A rifle fires a single projectile and a shotgun fires a sort of spray, although some of the stages also require slugs. So slugs are...
Ouch. How many you got to fire?
I think it's something like 20 to 40.
RIP your shoulder tomorrow.
Yeah, slugs suck to shoot. The other thing that really sucks is that if you accidentally engage a shot target with a slug, that is you're disqualified. You're done. So you gotta keep that shit separate. So I literally I've got a solution for this.
What does your belt look like?
Oh, I would have to I'd have to go and get the belt.
Is it covered like every square inch?
It has all the mag pouches.
How much does it weigh?
Lots. It has 4 pistol mag pouches, 2 rifle mag pouches, a dump pouch, and the holster. So I'm expecting to shoot something like somewhere around 250 rounds of each of shotgun, handgun, rifle. And it's going to be expensive. It's going to be a thing. The other absolutely idiotic thing I'm going to run is so for shot shells, you typically use this like caddy. And the reason why I use the caddy is so that you could go and grab them easily to reload. And one of the things I'm still trying to get better at it, but I'm not going to use shot shells or even dummy shot shells because I don't want you to get demonetized. Instead, I'm going to demonstrate with miniature hot sauces.
Oh,
because of course. But you grab 2 and you hold them sort of like that, and then you feed both in at the same time. So that sort of caddy makes that easier. But I'm only going to use the caddies for the non-slug. The slugs are purely going on a bandolier. So I've got a bandolier. And that bandolier
I'm not gonna lie.
used to belong to a client. They gave me all their gun stuff as payment for running their file, like all of the stuff that police seized.
You need to clarify, not gun stuff that was alleged to have been used in any defense that you were running.
It was relevant to the file.
Okay, going on. Moving on.
So, yeah, but it included this bandolier, and I was like, well, I'm not going to throw this out because it's a thing, but I don't have any use for it. Now I have a use for it. And somebody said, is it timed? It is absolutely timed. And everything, the winner at the end of it is the lowest score. Or the lowest time.
Oh, lowest
right?
time. But each
Lowest
missed
time.
shot is time. There are time penalties.
Every missed shot, you get a time penalty. Every shot you fail, like every target you fail to engage, you get a time penalty.
Yep.
So all of that, you get time penalties for everything you either miss or fail to engage. And yeah, it's I'm going to do badly. My goal is to not get disqualified. That's where I sit.
Honestly, it's not a terribly bad goal
Nope.
in the competition.
But I'm gonna bring the GoPro. I'm gonna try to film
Where are
it.
you mounting it? They wiggle.
I know they wiggle, but I don't really have a good mounting option. So
Yeah, I get
this
it.
is
Because
so yeah.
you can't do the chest mount, which is less wiggly because you have something coming across your chest every 2 seconds.
The chest mount, you'll just see my arm as I'm like shouldering the rifle. Yeah, there's just not really a good option. One day, if I get super like ridiculous money, what I will probably do.
Wait, nope. Chad has a demand, and I 100% agree with this demand. I need this demand to happen.
Give me a second. I'm going to show you what I'm going to look like as I run these stages.
Yeah, to give you an Ian doesn't give an actual fuck as to what he looks like.
Oh no,
at all. I does not care. Like, he is the most don't give a shit attitude, and it's the most fun to be around like ever. So
Rob has met me, and he's like, he's like, does that shirt go with those pants? And I'm like, fuck if I know. And he's like, oh,
they're on the same body, so yes, they do.
Yeah. Crud. Why is my? Hold on, I'm having some trouble with my GoPro mount. This might look even more dumb because it's not staying up. I gotta redo this.
Amazing. It is as amazing as I thought it was going to be. Oh my god! Oh, this is the most fantastic thing. Someone get a screen grab. This is phenomenal.
I know it looks like the most idiotic thing ever.
The only way that would make that better is if you did something like do a bandana across the front. Like a dust mask bandana.
What I need is to get like a GoPro mount that actually that has like the Runkle of the Bailey logo on it.
Yeah.
Somebody says we need the light up Canada hat. I probably can't wear the Canada hat because it won't go with the GoPro setup.
Or with pulling a shotgun or optics towards your face.
Yeah, or just running, because you do a lot of run, right? You do a lot of run, and yeah, it's a lot of the time. Like the one stage we were at, the 1 year. It was literally just you start at this point, and there is a target that is like 100 feet away.
Yep.
And you have a handgun. And you can engage it at whatever distance you want. And so all of the really good shooters, like basically just shot from like 100 feet away. And that was great. My strategy was I just ballsed out, sprinted to this thing, and then just unloaded into it from like 5 feet. And the thing is,
how'd you do?
My time was actually pretty good for that stage.
That's not bad, because the thing is, you got to bank on the guys from 100 feet missing a couple. Yeah, that's tough though. It depends on how fast you are.
There was another stage where there was a target that you, and I literally engaged the target from muzzle on because the stage allowed it. And I was like, all right. So
point blank on this thing. Point
blank the target.
Point blank on a target is one decision. It's a piece of paper, Ian. What did it do to you? My God. Like
it, yeah.
Walk up to the paper. Did you ask it for a wallet first, or did you just cap it in the paper? Like what?
I just capped it before it capped me. But the funny thing is, it was the last state. Like it was the last. I was the last shooter on that stage, and so I was just like, "Do you mind if I absolutely destroy your target?" They're like, "Not really. Sure. It's the last. It's the last one." So I was like, All right, let's do it. Somebody says, is my ear protection black too? Yes, but it's in ear. So it's not going to be a big sort of visible ear protection. It's going to be I bought really fancy ear protection at SHOT Show, and it's so nice. It's so nice.
Got the good stuff.
It's Axel.
Mhm.
I don't have a sponsorship. I really should get one. But yeah, it's you just kind of plug, like, they sit in your ears, and they're really, really good. They've got a really good pass through, to the extent that if you turn them up, you actually hear better with them in than without them.
It's so weird.
And yeah, they're comfortable. I went shooting. Yeah, it was good stuff.
I don't shoot enough to need to pass through. Like, I don't shoot enough to need to hear everything else. Like, I'm fine with my ISO tunes being in. Just that doesn't bother me. But okay, hang on. We have to catch up with questions because we're gonna miss all the relevant stuff. This is on the Sarah Boone topic. So, getting caught up. Hobson, the 7th attorney, has rejoined Owens' team. Sarah Boone called him a buffoon earlier. He withdrew for ethical concerns. We talked about the motion withdrawal.
How do you rejoin if you left for ethical reasons?
Because there was a defense that she wanted to run that he couldn't run. That was my opinion.
No,
I guess we'll see.
You can't rejoin for for once you leave for ethical reasons, you're just done.
I guess we'll see how it plays out. But thanks, Robin. Good. It's going to be fascinating. Baby Gator, thank you for the gifted memberships. Shannon S77, thank you for becoming a member. Megan, aka Meg, is autistic. Killing an abusive spouse in self-defense happens when the victim gives up hope of getting out of the relationship alive. He'll either kill her when she leaves or he'll kill her in the normal course of abuse. What's the victim to do? I don't think Ian or I are faulting that at all. No, we're not at all making an assessment of what should or should not be done in this situation. It is a very...
I am fine with more abusers getting capped.
Ian Runkle for president. We are speaking, because the thing is, with every self-defense case, especially in the context of interpartner violence, one of the things that I talk about relatively often is that you cannot look at these categorically. It is not possible. Every case is so fact specific that you have to actually understand the dynamic of each individual relationship, interpersonal dynamic, etc. So you actually have to get into the weeds before you can make an assessment on whether a defense is valid or not. So when I'm speaking to Sarah Boone and her ability to use and employ this defense, or when Ian is doing so, I am doing so in the light of the evidence that we have in this particular case. I'm not trying to provide a broad categorical analysis here. When we're speaking more generally about the use of battered spouse syndrome as a defense, we're speaking about flaws that we see in the use of that defense, well, more broadly, understanding that each case is going to be very factually distinct and might highlight some concerns that we might not see right now, but might see in that particular case. I hope that answers in some context your observations. But please, no, I am very much understanding and aware that this situation and dynamic does exist, and that's why the law recognizes that defense as a reality. Mary Coppola, my apologies, but he reminds me of Mr. Burns from The Simpsons, the lawyer. I can see that. Stephanie Smith.
We need to get him a cane.
Oh, God. Wasn't this privilege an issue with Murdaugh as well, with attorney friends? It was, and there was parts of it where you actually saw some of the invasion of that privilege with communications with Jim Griffin. So you saw that come out in that trial. Mary Coppola, are there stats on attorneys' win-loss tenure? No. And for very good reason. One, criminal defense. You never ask criminal defense attorney what their win-loss record is.
You just can't.
You can't.
And the question of what a win is,
what a win is
even a hard question.
Yeah.
So, for instance, I had a client who went to jail for 6 years. Does that sound like a win?
Depends on the case.
I can tell you the client was absolutely thrilled.
For the 6 years.
Yep. What is a win can be a huge, huge issue. You know, and sometimes, like, you know, your client getting a fine could be a huge loss on a file. Whereas on another file, getting a few years is, the thing is, it is very difficult for non-lawyers to, one of the things people ask me is, they say basically, how do I find a good lawyer? And it's very difficult for non-lawyers to identify
Good lawyers.
a good lawyer, because the other thing is the best sign of a good lawyer is one who can take a shit case and turn it into an excellent case, or turn it into a viable case, right? Whereas sometimes lawyers look good because they start out with 4 aces.
Yeah.
And it's like, you just can't lose, right?
Yeah.
I've had cases where I walked in and I looked like the hottest shit ever because
You had great facts.
I had all of the facts, and it was just like, I get to just spend the entire trial dunking.
Mhm.
And I've had trials where I walk in and I probably did not look super fantastic because I'm trying my best to poke holes in the other side's excellent case. So yeah.
I mean, some of the cases I'm most proud of, actually the cases I am most proud of, are the ones where I get the case 3 years into litigation. Ian's also in unique. Well, family law is unique because family law, we have clients for long time. Contract dispute, you have a client for a year. Criminal case, client for 18 months. Family law case, we have clients for up to 18 years. And sometimes beyond that. So there are some cases I'm the most proud of is where a client comes to me after they've had a case going on for about 4 years, and every decision made prior to them coming with me was against them. And it seemed like the entire weight of the case for the entire case history has been against them. And I have that initial discussion, like, it's going to take a while to right the ship, right? You can't turn and pivot the Titanic in 2 seconds. Bad example, Titanic sank. You can't pivot a massive cruise ship in 2 seconds. You got to do it slowly. But to have those cases, be able to turn them around over the course of a year or two after litigating it and getting it turned back to even or in my client's favor, are the cases I'm most proud of. So
one of the ones I'm hugely proud of is another lawyer had the file, handed it off to me saying, I double booked myself. Can you take this file on? It is a sure loser. So you're going to lose this file. You don't need to worry too much about it, but you're going to lose this file. And I won the hell out of that file. So it's nice when another lawyer says this file is dead in the water, and you can just be like, no, it isn't.
So on the win-loss record, I get to give the answer that every lawyer gives in the world, which is it depends. You don't know what a win is. You don't know what a loss is. Chris Cat Queen, does he want a cookie now? That's for taking on the case. I think he wanted more than a cookie. Lady Fang, wow, Sarah and this lawyer are the perfect match. I'm flabbergasted, but I'm glad she has an attorney.
This lawyer tremendous credit for being
taking
willing
this case
to sign up and take it on.
This is a shit sandwich. 30 days prior to trial.
That's the thing, is I don't think there's a happy ending for this lawyer. I think it's that he runs the file. People online mock him because it's gonna look shitty for him running it.
It's an impossible client. It's an impossible client. You know she's going to want to test it. She's going to demand to test it. There's no world in which she is not testifying, and there's no world in which any lawyer leaves that courtroom with a single piece of hair in their head after that discussion of telling her not to testify.
And that's the thing is, it's gonna suck really hard. And I give him points. Like he says, "Oh, she's gonna pay me back." She's never gonna pay you back, dude.
And he knows
And
that
he
too.
knows that. Yeah.
He does. He's not. He knows that. Even when you heard him say it, he knows it well. He's like, I've
Oh,
been
yeah.
retained. I've been retained. She's gonna pay me. He knows damn well he's not getting a penny. It's not possible.
That said, I did have one client who was this lovely old lady. She had no money. And I asked her how much she could pay per month. And she said $50. And I'm like, okay. And she refused to
Yep.
do the file, like for me to give her any discount or anything. I still did. I just kind of was like, yes, this is my full rate. You know, but yeah, so she paid that $50 a month religiously.
Yeah.
And
That's pretty
finally, she calls me up and she's like, here's like $2,000. We're going to be square. And I'm like, what happened?
Just-
She's like, a friend of mine died. And I was like,
Sorry. That was bad.
well, she
Sorry.
sounded really cheerful about it. And I was like, you didn't like them? She's like, no. And I was like, okay. And I'm like, how's this person a friend? She's like, well, when you get to my age, people you know for long enough are your friends, even if you hate them. And I'm like,
Some
okay.
part of me deep down understands that. I don't know why yet, but I think I get it. Just because saying, would you say a fighting chance? Oh, very cute. Common dirty words, foul, unladylike language. It's going to be interesting watching any of that audio. Robin Day, he was elected the public defender in his city per Peter. I can see that. I don't fault the guy. Like I said,
he looked like he was actually pretty good. I didn't like that he was talking too much out of school. I think a lot of the things he said he shouldn't have said, but I don't think any of the things he said are ultimately going to blow up the client's case.
Yeah.
So
and let me get back to giving this guy this credit. Like he voluntarily took that case, knowing beforehand what he was getting into. Wasn't appointed. He walked into there and said, I get it. Here I am, judge. I can do this.
And maybe this guy is, I'm the kind of crusader weirdo who would step up and be like, nobody else is running this trial, so somebody's got to do it, and I'm somebody. And if he's like that, I will 100% give him all the props because that's a tough place to be, right? So, yeah.
I'm with you on that one. WW Batman and Robin with Clooney. Ouch. That was the worst Batman ever. Sharon Leberthon. I'm sorry if I messed that up, Sharon. Missed you, Rob. Hi, Runkle. Love hanging out with you guys. Hubby and I celebrated our 3-year anniversary today by jumping out of a plane at 14,000 feet.
I could not do that.
That's not it's not a low jump either. Life after a double lung transplant is amazing. Holy crap. All right. I'm toasting that.
That is
awesome.
I'm going to lift a glass to that. I can't drink too heavily.
You have to handle firearms more. I do not. Sharon,
the thing is,
congratulations to you and your husband.
I have never in my life drank enough that I was still drunk the next day. But the last thing you want is to be hungover as bang.
Yeah, that's a terrible experience. But
so
let's highlight a good experience, which is jumping out of the airplane for your 3 anniversary after having a double lung transplant. Successful. Way to go. I hope you live many more happy years together as husband and wife. Cheers to the both of you. Maybe at year 5, you do something less complicated, like, go on a walk. You don't have to jump out of an airplane every time.
I kind of feel like this is exactly the awesome thing to do in did you see what Mrs. Runkle and I did recently?
No.
we went to a bouncy castle. They built a giant adult bouncy castle.
Where did you
and
share this with me?
I posted this to Twitter. I posted some of these things to let me
Ian?
see if I could pull up one of the pictures.
Ian, the amount that you post to Twitter, if I miss your Twitter for a day while you're pulling up the picture, I did want to pull up Torin's comment. So Torin makes a comment, since Ian is on, I wanted to share my respect for Paul Harrell's passing. Yeah.
Yes.
Ultimate badass. I mean, the dude was just a rock star all the way through the diagnosis, everything, all the way to the end. Also, Ian, I'm in
You
and
know
out
how
of hospital
much
now, and go ahead.
You know how much I teared up when he apologized for dying?
Yeah.
I'm going to share screen, and it's going to, I think it's going to, kick you out there. So 1 second, or where do I?
Let me finish the rest of the sentence. Also,
Oh,
Ian,
yeah.
I'm out of the hospital now, and Braid will be mailed by October.
Awesome.
This is why Ian and I can't be in the same room for too long because we're both children, like just adult children. We need adult supervision. This is an adult that needs adult supervision. This is the coolest. That's a big ball pit.
They had a ball pit that you could sink into. It was pretty awesome. Some people are asking, who is Paul Harrell? He was sort of a gun tuber. But he was very apolitical and very much. The only time I ever saw him salty was there was some weirdo who basically said Paul Harrell doesn't know shit because he doesn't. He's not he's not actually a good shooter. And so the video Paul Harrell did in response to that was
just him shooting.
No, it was those folding plastic tables?
Yes.
He always films in the woods.
Yes.
And so he pulls out his medals for shooting competitions, and he sets them on the table, and you see the table go oh shit. The table is I need an adult, because it's just sinking down, and he's so I think I know what I'm talking about. And that I thought was and the thing is, it's a really classy sort of response to it, because he's just okay, maybe I don't know anything. Thump.
I mean, dude's also made of nails. They don't make him like that anymore.
Well, and I mean, he, up until the end, he was not really telling people how bad it was, because in his final video, he noted that he was seen on crutches towards the end, and it was because the pancreatic cancer had gotten into his bones. And he's yeah, what happened is my hip fractured, and then I fell. It's I didn't fall and then fracture my hip. It's my hip broke, and then I fell. So things were bad. And I'm
yeah.
Oh, shit. Yeah, Harrell was, I was sad. So remember the Gundys last time?
Yes.
Paul Harrell was set for an award.
I know. We were there.
He was, of course, way too sick to attend.
Mm-hmm.
And I was I was sad about that, because had Paul Harrell been able to attend, I would absolutely 100% have found that is the guy who I would have wormed my way through the crowd to been dude, I know this, you hear this a lot, but I am a tremendous fan. And yeah, it's sad. You can miss somebody you've never met. And that's kind of the case there. So I don't have a glass. I don't think
You can say a positive story, because Patty Hoffman, I think, doesn't. Patty Hoffman obviously is, well, not obviously. I don't mean to say that negatively.
I'm gonna grab a glass and then I will tell the story.
All right, Ian's gonna grab a
Wait
glass. I'll bring
1
that back.
second.
Go do that.
1 second.
Sounds like an SASS shoot. I'll hold that for Ian when he comes back. Oh, Megan, I didn't view that negatively. I made that comment when you were talking about prosecution pointing out that she could have left the thing. I hate that argument. I was lucky to leave. I understand that. I was pointing out the law that the prosecution is allowed to argue in that case and how it's complicated in Florida. And I know practically, as a practical matter, that doesn't always play out at all. And it feels really gross to have someone be able to argue that. So that's the only reason I was highlighting that, because that's the law that they face in Florida. Seth, I took the come out swinging comment was towards her.
Back in.
Yep. SF, I took the comment, come out swinging comment was towards her conduct in court and all the letters and such, not about her excuse for the alleged crime. I know that too. I took it that way too, SF. What I am saying more is that when you realize the media is covering the case, that you should probably pick words that are a little different when referring to a case of this nature. SF, thank you again. Glad you're back, Rob. Missed you this summer. It has been wild, and it's just been about a month and a half and 2 months. It's been the move that's been killing me. Deanne, love FNF. Thanks for the laughs tonight. Jen says, good luck, Ian. Thank you, Jen. XCDA, I love being a fly on the wall of Rob and Ian catching up tonight. You get that, and you now get this. The story of why Runkle has Rob's tie. So to those of you who are new to this dynamic of this Canadian criminal defense attorney and me, a family law litigator in Virginia, we met during the Johnny Depp trial, and Ian was a guest in my home during that trial. Actually, after having just met, like Ian was like, I want to come to this trial.
Like, Alita basically said, hey, you're going to be in Virginia. You're going to the trial. Rob's going to the trial. You guys should talk. And so, like, I think we messaged. I can't remember, like, if it was text or what, but we were
Twitter.
sending messages. And so Rob is like, where are you staying? And I'm like, I don't know. My plan was basically to arrive and then go to hotels with my computer and check their internet while I'm there because I need an internet connection. And Rob's like, or you could stay with me. And I was like, I did not expect that was like, I didn't think that was a thing. Sure. Now, meanwhile, I'm like, I hope Rob is not an axe murderer. And Rob is probably like, I hope this guy's not too weird. And one of us was lucky enough to be
correct. One of us was right. One of us was lucky enough. I was not an axe murderer. That was the one that was right.
But so I'm staying there. I'm doing live streams from his table. He's feeding me his homemade beer, which is actually excellent.
Oh, and food while you were streaming because you forgot to eat.
Oh, yes. I'd be sitting there streaming and Rob would be like, yeah, I made food. Put this in your face. And it's like, oh, right. Because, yeah, that is the thing. I slept on the sidewalk sometimes. Rob was hanging out. Rob was going into the trials. Rob, and it was just like, sometimes you meet somebody and you're just like, why was I not friends with this person sooner? kind of thing.
It's fair.
And yeah, it was awesome.
Forgot the tie. Ian didn't have a damn tie.
I forgot a tie.
All the way to Virginia to go to court as a lawyer to sit in court and watch a trial, and he didn't have a tie.
And one of the things is like, if I go into a courtroom, I wear a suit. And that's like, even if I'm going just to watch trials, and that's even in another country, I'm going to watch a trial, I wear a suit, I wear a tie, but I forgot the tie. And Rob's like, I got you. So
it turns out, so that tie that's sitting on the handle of his door right there. That is and was my lucky tie. I would wear that to court with my blue suit whenever I wanted to win a trial really bad. So I gave him my lucky tie to wear. And honestly, we go to court a couple different days, and Ian goes back to Canada, and I get a text message from Ian during the break in the trial. So this is during the break in the trial. So Ian flies back mid-trial, texts me with a picture. Hey, forgot that I had your tie in my bag. I was like, okay, no problem. Bring it back when you come back. So towards the end of the trial, Ian comes back. And he comes back and he brings the tie. And he brings the tie and he wears the same tie to court. Wears the same tie to court. What happened, Ian?
I have had good luck with that tie. I've lost once with that tie out of several court appearances with it.
Yeah. So the tie did not stay when it came back. The tie went back home to Canada. And every time Ian goes to court. So Ian will post selfies of himself going to court. And I want you to count how many times he's wearing that tie when he's post those selfies. Because that tie still has a good luck streak. So that's why the tie is on his doorknob. Now, there's a caveat to this story. And unfortunately, I don't have all of my accoutrement behind me that I usually do because I'm in my new studio. The caveat to that story, or the follow-on to that story, is that I went to go. Ian invited me when he was nominated for an award at the Gundies. And he's nominated for an award at the Gundies. And we show up in Texas for these awards. I'm his +1, as is Devin. We're both +1. It's phenomenal. We love it. It's fake. It's great. I got a picture with a fucking rhino. It's awesome.
They allow you to bring 2 people because they expect that you've got like a camera person and whatever else. And meanwhile, I'm like, I don't have any of that. So Rob, Devin, come have fun.
So we join him, and I'm there, and Ian, on the night of the awards, he is up for Voice of the Second Amendment, and this asshole wears a Canadian flag tie. He's nominated for the Voice of the Second Amendment. He wears a Canadian flag tie with the big old maple leaf right in the center of it. Just Voice of the Second Amendment, United States Constitution, Canadian flag.
It would have been so funny if I won that.
It would have been great. Instead, he won Breakout Content Creator of the Year. So we are going through the airport, and I go to the restroom, and we say our goodbyes, blah blah blah, and I get my ass all the way home thinking about how much fun I had and what a great adventure it was. And I bring my suitcase in the house, and this part always kind of gets me a little bit, but I bring my suitcase in the house, and I start the process of unpacking, and I open the damn suitcase, and what's sitting there at the top of the suitcase? Fucking Canadian flag tie.
I smuggled it.
Son of a bitch smuggled the Canadian flag tie into my suitcase. So it's commonly referred to as the Brotherhood of the Traveling Ties, where Ian's got mine and I've got his. And we kind of keep those ties around just as a symbol. So that is the story of the tie. So if you see people, go ahead.
The other thing that is like, people get like upset if the tie isn't there.
Oh, they get mad.
So like, I had a tie. I went down to Calgary to run a trial or for a court hearing, and it went great. Tie once again does its thing. But because I'm going down to Calgary, it got packed into a thing, right? So everyone's like, where's the tie? Where's the tie? And I'm like, it's in my suitcase. I'm just awful at, at unpacking things. And people are like, no, where's the tie? And I'm like, okay, I gotta find it and put it back, because people will have opinions.
People get very upset. Tina Kawaji, thank you for the lovely gifted membership. Where does one buy prescription safety glasses that cheap? From H Scorpio. Ian, that's for you. Where do you get those safety glasses?
I Googled like something along the lines of like Prescription Safety Goggles Canada, and one of the sites that does like cheap glasses. Yeah, one of like they had it. They basically, this was the cheapest model that they had, and that's because they basically come with a guarantee that that, and I mean, I don't have to worry about this, I'm married, but they basically come with a guarantee that you will have no prospect of ever landing a mate if you're wearing them.
Mm-hmm.
I actually feel like if you what is it? I actually feel like if you wear these glasses, you actually have, as a result of that, had less sex in your life just because you've now put the glasses on. It's like undone some of the.
It's a repellent. Like it's just a negative.
It just cancels things out retroactively.
Honestly, if they're effective safety glasses, I don't care.
That's kind of. Now, one thing I do regret is that at one of the events, I met some people who do like nice looking safety glasses that are prescription. And they gave me their card and they said, contact me and we can hook you up with some better looking safety glasses. And then I lost it. So I don't know who I'm supposed to track down to get
Safety glasses that are handsome.
Or at least not quite so repellent. Yeah,
don't let Mrs. Runkle hear that you're looking for less repellent safety glasses.
I mean, it would be okay if I looked like less of a moron. And I mean, I get that that's false advertising, but
can I say something that said? Can I say something that said with all of the heart and that I can ever muster, that I hope that you receive the right way?
Yes.
Out with Ian in public. And please, people, take this the right way. He is the most adorable bumbling idiot that you would ever see in your life. Like it is. There is a drum that he is carrying, and it is his own damn drum, and he is beating his own damn drum, and he is walking to that beat, and holy shit, he is in his own world. It is the coolest and most adorable thing. You're like, Ian, hey, over here, focus. No, this way. But honestly, when it comes to being a friend, that same level of like hyper focus and attention, that's what he puts into the friendship too. So
the thing is I'm not always great at it, because I will do things like forget that people want to keep in touch. And so it'll be like, I got into a video game and I forgot to message somebody for like 6 weeks. And then they just assume that I think that they're an a-hole. So I do that, and then I like message them back, and I'm like, "Hey, I saw a neat thing," and they're like, "Where have you been?" Like, I moved on. And I'm like, "Oh, that is sad." That's just kind of how attention deficit works. I'm bad at that, but like, I mean, when somebody's a friend, they're a friend, right? So
they are.
And I'll fight for them.
I might not hear for you for like a month. That's never really happened. It's never really happened, but I might not hear for you a month. Then all of a sudden it's like, so I have a random question. And when I say a random question, like, holy shit, like buckle up, Buttercup, because when he says he has a random question,
sometimes they are the most random.
You could get a, does this work? Like this drill bit on this particular setup, or so I'm running this criminal defense and this is the crazy case I want to do, or so there's something really dangerous I want to try, and you're like, what to do? Okay, yeah, you get anything. LJ Peach says, sounds like an SASS shoot. I didn't know what that was.
I will probably have to look that up. There's so many different shooting disciplines now. Oh, single action shooting society. Okay. So that's like cowboy action stuff.
There's fun.
I want to do cowboy action. The problem is I'm having a lot of trouble finding a lever action. I don't know why, but like lever actions seem to have just vanished out of Canada.
Wasn't the one that was on the Rust set we both were drooling over?
Oh, I mean, some of those I'm just like, ooh, I wish.
Is it the 357?
What I want, I've got a 357. I've got a pair of 357 single action revolvers, and I want to get a pair of, or I want to get a lever action in 357 with a side loading gate. And I haven't really found a good one for that. And I want to, once I do that, I need to buy a shotgun that is SASS legal. So, yeah. And then I'll go to matches. I'll compete in that. The thing is I'm going to suck, but I also, so one of the things about cowboy action is that you are also expected to shoot, in cowboy gear.
Maybe I just want to shoot the single action.
Like
I just do that.
They'll let you, unless it's like a serious tournament. Some of the serious tournaments have rules about that, but a lot of that they'll let you. But like people go to all sorts of effort to dress up, and some of the like serious competitors are doing it in very elaborate costumes. But yeah, I mean,
so for those in the chat that are not gun savvy, a lever action rifle is what is a safe picture that I can put on?
Here, I can pull up a picture. I've just found one here.
Here we go. Hang on, I got one.
I got a better one, and I'm going to be faster.
Honestly, they're so gorgeous, and that's that's a lever action rifle. You just swapped it out, you son of a bitch.
Yes. That is also a lever action rifle.
Also a lever action rifle.
And this is a couple that does cowboy action shooting. This is the gear they do their competitions in.
Okay, I hate it less now. Maybe a little bit.
I just gotta say, does this guy not look like an absolute badass? Her too, but I love the hat.
I'm a big fan of the cut, like the facial haircut. Like that's a particular look. It takes a particular person to pull that off. And
not everybody can pull it off. I certainly couldn't. He can.
Not to mention, she is not the person that you would want to break into their house, because I imagine bad things would befall you.
I feel like these two just walked out of a movie.
They did, clearly.
And like, but yeah, they got their revolvers. They've got, and the thing is, the leather work that you see from some of those. Oh my God. Oh my God, the leather work.
It's all custom too, because they don't make it. Like it's all custom.
I was talking actually to the chief firearms officer of Alberta.
Mm-hmm.
And she was showing off a bit of leather work she had, like a bit of like a custom holster.
Mm-hmm.
Oh man, it was nice. It was so nice. And I was just like,
so on the topic of, you guys see, I'm going to do a natural transition. This is going to work really well. Hang on. Natural transition made less natural by swoop. So on the topic of old-fashioned firearms, and Westerns, single action firearms, firearms that only shoot upon a mechanical pull of the trigger, individuals that pull triggers of firearms and charges resulting there too. And how many
Oh,
more
I know where we're going.
they stall for trying to. I was in the wrong folder. Damn it! I'm sitting there stalling and going, "What are you?"
We're talking about Baldwin.
We are. I even threw a swoop in there. So, Alec Baldwin. Y'all remember that Alec Baldwin was going to trial and was in trial for, was it second degree? I'm looking for the damn order.
The order responding to the
Single page. It is a single fucking page. Sorry. That was
the thing
loud.
is, I kind of expected that.
I did too, but what made me laugh a bit was
Is the reason?
well, it's not the reason. It's the media having to backtrack on stuff. So the media got it wrong. Go figure. Surprise, surprise. They always kind
no.
of do.
That never happens.
No. They would not ever get it wrong. There's no possible way. What accent was that? That was horrible.
I don't know, like Valley Girl crossed with Scotsman, crossed with like a fifth
Cats.
of tequila.
Screeching. Cat screeching.
Yeah.
All right. So Alec Baldwin. And that was actually just intended to be from like Team America. Alec Baldwin. Terrible movie. If you like the insulting stuff, it's phenomenal. I just saved it. Where'd it go? Order Baldwin. Where did you go? Where did you go now? There we go. All right. So let's go ahead and pull up what was filed. So, and did you cover the motion to reconsider the dismissal?
Not
already?
yet. I'm planning on it, but
We'll save it. We'll save it because the thing is, I want you to get to the substance of it. I want to get the punchy stuff.
I mean, you know my style, which is I go through things in excessive detail.
I know.
I had somebody who's like, why aren't you covering this in or why don't you do a short version? I'm like,
it's not possible.
Because that's not really how I roll. I'm the channel if you really want to go through something in so much detail that you are like, I know this as well as the lawyers know this. That's where I like to be.
The Birchmere. When you did Birchmere, I watched that stream, all 5 hours of it.
Sorry.
No, I very much enjoyed it during the times that I was working around the house. That was very thorough. And I very much appreciated the fact that you had a lot of background that other people did not have. So I would absolutely commend that.
I had a lot of rage.
Yeah, you had a fair bit. So Judge Mary Marlowe Summer, I love this judge. Love this judge.
She is so good.
So this motion is filed by Carrie Morrissey. For those of you who don't recall, Carrie Morrissey was the lead prosecutor on the case of New Mexico against Alec Baldwin, the case that was dismissed with prejudice when there were certain issues with discovery that came to light during the trial that could not be cured. And the judge came off the bench like a total badass, put on gloves and said, give me this one, give me this one, give me this one, give me this round, and then asked the prosecution witness saying, were any of these rounds that you just gave me here in my hand similar in nature to the ones that were discovered on the Russ set. And the witness said, yeah, this one was. The judge looked sternly, and you kind of knew then that was the ball game. The judge did the right thing. Most judges in that situation would likely have found some exception to the prejudice. And I don't mean most, maybe, I don't know, 50-50 split. A judge would have found an excuse as to why it wasn't unduly prejudicial to the defendant to move forward in the case. This judge did what I think was right, which was basically saying, prosecution fucked this up to the point where we can't fix it, and therefore we're dismissing the case with prejudice.
I think she made the right call.
Me too. And for me, that sucks because I felt factually that Baldwin was criminally culpable for the conduct that he engaged in.
I agree.
So it sucked to see that happen from a factual standpoint, but from a procedural standpoint and from the greater scales of justice weighing how the court is supposed to work, this was the right fucking call. And it sucked to have to say that. Like it really.
I did a video that I got some shit over where I basically said, hey, listen, I think that that there's a risk that if Morrissey keeps fucking around, that this gets blown up because like she needs to stop fucking around.
This motion is a bit of fuck around.
And the thing is it really makes me sad because I was giving Morrissey credit for
she's a bulldog.
I thought she was spiking the file, but also making sure that everyone saw the police fuckery. But nope. Apple Silver, I don't know which your question is, so you'll have to re-question your question.
Yeah, Apple Silver. I'll try to see it if I see it in the chat. But Morrissey, remember that list of attorneys I told you, the 5 that I wouldn't want to litigate against?
She's on that list.
She is. And with Morrissey, based on the conduct that's come to light, I don't know whether I wouldn't want to litigate against her because she's in the 3 that are just gonna litigate every issue, or the 2 that I think are unethical. And I'm torn. I think that Ian's right that she's playing a game of F around and find out. And the more that she plays this game, the more that she's pushing me in the direction of, I don't like where you are on this. When Morrissey started this trial, when Morrissey was litigating the Hannah Gutierrez Reed trial, I had a lot of positive things to say about her. People would perceive that as positive. I appreciate the style of litigation, the tactic of litigation. The people on that list of 5 that I listed, the 3 that are in the ethical camp, I appreciate the style of litigation. It's not mine. It drives me crazy, but I appreciate that is their style. They are bulldogs. They will fight every issue. They will never concede a single point, and they will make you scratch for every element of your case. They do it without being dirty. They play the game as it exists. They play the rules as they're allowed to be played. They do it right. Morrissey. Go ahead.
The lawyers I have tremendous respect for are the ones who are willing to cut the case down to the absolute center of it and argue that.
Yep.
And just get the case done quickly and efficiently. That's where I like. Yeah. When I can, like when my client has a good issue on one particular issue, I will try to be like, okay, this is the issue we're going to argue. We're going to skip, like we can skip over all the bullshit and we can just argue this. And sometimes I've been able to convert like a 5-day trial into a 1-day trial. Because I'm like, I'll admit all the stuff I know you can prove, right? Let's just get to the thing where I think I'm going to win. So,
and the judge, here's the thing. You can get a judge's focus so much better and a jury's focus so much better if you just get to the heart of the question. Now there's an art to it because you have to leave enough context in so they understand the question. But parts of Morrissey, I appreciated the tactic. It's not mine. I don't like it. I don't use it. I don't like litigating as attorneys who do, but I saw a part of it that was like, I get it. And then I saw a little bit of gamesmanship, and I was like, you know, I don't really like this. Not really fair, but it's up to the other side to call foul. And particularly with Bowles, I thought Bowles was, how candidly should I speak on this regard?
Candidly.
Bowles was inept.
There were times he was an outright chuckle fuck.
He was inept. He the fact that he was entertained at CrimeCon to speak intelligently on this issue.
Oh, I was raging.
Is shocking to me.
He wasn't speaking intelligently. He was doing damage control.
He's an idiot.
I mean, I was just super.
I don't think he has a touch for litigation. I don't think he could smell an objection from a mile away. I don't think he stood up and protected his client in any regard. I think he got steamrolled in rebuttal evidence and that should never have come in. I think he handled Cross terribly. I honestly think that he,
I mean, the
while
big
competent
thing,
counsel was just botched that case.
the thing that just is absolutely unforgivable from a defense lawyer is the police interview.
Yeah, I'm never going to get beyond that ever in my life.
Because I actually want to show, like, one of the things I want to do. So for the people who don't know me, my big dream is to have YouTube be my job and then do law for free, pro bono. Never take money ever. Like, just literally, I don't take money. And if I get to that point, one of the things I also plan to do is I plan to teach a course at the law school. And I want to ask them, I'm going to teach firearms and weapons law again if I can. But I also want to ask them if I could teach a course on advocacy through trials. And so what it would be is, like, we're going to look at all these big trials. We're going to look at the Depp trial. We're going to look at the Rittenhouse trial. We're going to look at these trials, and we're going to learn advocacy lessons from these trials. We're going to break down these cross-examinations. And the lesson I'm going to have here is watch this police interview, and isn't it the worst thing you've ever seen? Correct. Like, this is what you should not do as a lawyer, right? Your defense counsel. Your job here was get your client the fuck out of there.
And you failed miserably at that job.
Oh,
So-
and the thing is he was there to spin a narrative, and they blew up his narrative in front of him, and he doesn't get out of there.
And he didn't
Like,
understand. He doubled and tripled down on a narrative. Like, he didn't just go down with the sinking ship. He threw the motors full ahead.
Oh, it was bad. Oblada is asking, do I get any of the super chats? No, they go to Rob. I'm here as a guest. Like,
Yeah.
And they're like, don't try to stir up stuff because we're good. That's how that goes. We know.
You will notice that I will jump into Ian's like chat when I can't be on with him, and we share love back and forth, buddy.
It's all, yeah, we're good.
Also, Oblada, here's a really good point. If you want to give money to Ian and not to me, good, wonderful. I love it. I will never not encourage that. Please go to his channel. Under his videos, if you watch one of his videos, in the comment section, you can leave what's called a super thanks. It's not a super chat, it's a super thanks. You can go in the comment section of the video, leave a super thanks, or there's a better way of contributing to Ian's channel, which is to contribute via
I've got a PayPal, but the other thing I'm gonna suggest is that people can also contribute to the Extra Life. I get 0% of the Extra Life donations. I get none of that. That all goes to the Stollery Children's Hospital. Last year, we raised over $100,000. I'm gonna try again this year. I don't think I'm likely to pull it off, but
Do you have a link yet? Can I start sharing it yet?
I totally have a link, and I will totally drop that in the private chat.
Should be able to look it up.
It's on my Twitter.
Got it.
So the last couple of years, I was #1 in Canada. I keep trying to make it onto like the top 5 leaderboard. Right now, I am ranked at 647, so I'm way down there. But when I make it onto the top 5 leaderboard, then what happens is the top 5 is always companies. And the companies want to be on the top 5. And so what I love doing is what you'll see is that somebody donates like $100 to me. And then you'll see a company go, oh, we're going to donate $100 to get above. Or they'll dump like 10,000 in to be like, screw this guy. And then we catch up to them. And they keep having to throw more money into their own Extra Life. And it all goes to hospitals. So every time we force them to donate more money,
it was great.
We have just been like, oh, yeah, by the way, you got to pay more. We just force more cash out of them. And I love it because it's basically now you get double or triple the value out of it. It's where it's awesome. So,
and if Extra Life it's in November, right? Yes.
November 2nd, I'm going to be doing a 24-hour live stream. I am going to have, I'm starting to reach out to people to also get donations. I'm going to hit Rob up. I'm sure Rob, if he's got like a pen or something, I'm hoping I can persuade Rob.
I've got a couple. I've got a couple. The pens did well last year. I think the pens raised 22,000.
Oh, people hammered that, and that was amazing. I'm also going to do I got to do a serious leatherwork project. I've got some little things, like I got this little leather pouch made with some really interestingly patterned leather. It's got my sort of maker's mark branded into it. Last year I did this very elaborately tooled leather journal with sort of a phoenix logo on it. And
it's gorgeous.
I'm going to try to do something similar to that because, it'll be a lot of fun. So if you're going, hey, I want to contribute, that is also like, I will never be upset that you sent money to sick children because that is where I want you to send the money, right?
Or Ian Runkle, who wants to do pro bono streams.
Either of those is good. So, yeah.
I don't ask for the super chats. I don't. It's for me, I just like talking with you guys and sharing a lot of it. Like, I want you to engage with each other, the community, the people. I want you guys to participate. I want you to be here and hang out. I want you to go and support my friend Ian. I want you to go and support Extra Life. Last year, the amount of money that got raised it almost brought tears. Like, it was phenomenal. So,
it was amazing.
Please.
And the other thing that was just so much fun, we achieved our goal last year, and then I was looking at the so there's the local Extra Life fundraisers like Discord, and so there was a guy on it, and he was like, I've been streaming for 18 hours and I haven't had a donation yet. And I looked into it, and like I went over and looked at his channel, And the guy was like, he got into this because of like a sick family member or something like that. And I was like, okay, folks, we're gonna have some fun. I want you to donate over to I want you to donate over there. And so suddenly I'm like watching this guy and he's just like losing his mind because he's like, what is happening? Because suddenly people just started coming in and donating, and they took him like way over his goal in like, 5 minutes. And it was just so much fun to watch.
So to Mrs. G's question, the Extra Life link is pinned to the top of the chat. You should see it pinned to the top of the chat, and my mods can be sharing it intermittently as the chat goes on. But Ian's Extra Life fundraiser is already live, so you can please go ahead and consider donating. He's at $637 already. Oh, 817. So some of you jumped over there and donated real quick. So he's
Also,
817 already.
I need to do a puzzle because we stopped. Mrs. Runkle and I went on a camping trip.
Can we build Legos during Extra Life?
We could absolutely do a Lego thing, although I'd want to
I wanna
ask
do that.
MLS for his permission.
I'm pretty sure he'll grant it, but can we build Legos? Because I had so much fun doing that.
Somebody says, can I share a picture of the leather journal? Yes, except I don't have one
Okay.
ready to go.
Why don't you, if you look for the picture,
I'll have to track it down. But the
That's
Lego,
pretty cool.
like this, we stopped at this little, like a gas station / restaurant / whatever. And that they made their own puzzles. And I was like, all right, so what I'm planning on doing is I'm going to do at least part of this puzzle so I can sign it. And then I can take it apart and put it back in the thing and put that as one of the auction items. So yeah, we'll do that.
okay. We're going to refocus.
Fair.
Extra Life link is at the top of the pin chat. Refocusing. So Carrie Morrissey, back in the topic. Alec Baldwin. The entire case gets dismissed because Carrie Morrissey was, playing a judgment call on what she considered to be relevant, which isn't really the job that you're supposed to do as the prosecutor. You're not supposed to, as the prosecutor, make an assessment of what is or is not relevant. You're supposed to turn shit over. That's your job. So Carrie Morrissey kind of forgot that she was no longer a defense attorney and was like, I'm a prosecutor now, but I don't really remember that I have an obligation, and didn't turn shit over because she didn't think it was relevant. So she filed a motion. And when I say she filed a motion, she filed a 52-page motion to reconsider the ruling. Julie needs to swoop for the 52-page motion.
You just got to take the L, folks.
I know. So a motion to reconsider. People don't really know what this is. You have within a certain period of time after the judgment is rendered to file a motion to reconsider that judgment. So the court can basically say, I made a mistake, I made a boo-boo, or I did not. In which case the judgment comes final and you have to appeal. Now the motion to reconsider has to be filed within this period of time because the court loses jurisdiction after that, right? So you have to have the court rule on it within a certain period of time. So Carrie Morrissey saw this dismissal and was like, I'm going to file a motion in response and say, no, judge, you should not have dismissed the case because you were wrong somehow. I don't know how you get there, but she was very, very adamant, 52 pages adamant that that's what she was going to say. And Ian's favorite phrase in every pleading.
Oh, God.
You can say it.
Comes now, which
Yep, I know.
I want to destroy this phrase, and my plan for destroying it is that someday I will commission a porno titled Comes Now. It'll be a legal themed porno. It'll be set in like the Victorian era. It'll be the most cheesy thing ever. Intentionally so. and I will send it to every lawyer. I will do a search. I will hire someone on Fiverr to just be like,
To just
find every
disseminate
single
it?
lawyer ever, every web address you can find for every lawyer, and send them a link to this.
You're gonna
Also, every judge. And just like, I want to ruin this phrase for everybody.
well. So to your credit, Ian. Here's the thing. People in my firm have started to. I am now viewed as one of the more illustrative writers in the firm, like for my pleadings, etc. And I've started telling and teaching the younger associates, you don't have to write like a stiff, like you don't have to write like they did, like just
Absolutely, you don't.
write your motion. Like and the judges, how many times do they read that shit? Just write your motion.
I had some people give me shit for basically with citations, instead of using IBID and Supra, I just copied the citation every time.
Yeah.
And I had some people give me shit for that. And they said, that's not how you do it. That's not right. That's not proper. That's not correct.
I can do it. It
Well,
eats against my word limit. But
I mean, the thing is, it doesn't really. What do you call it? I submitted this to the Supreme Court of Canada. And the Supreme Court of Canada will bounce anything for even the slightest. Like if they say 12-point font and you submit 11-point font, they have a clerk who's got a ruler who will hold it up to your page and be like, nope. And so they'll bounce it for any mistake in format, and they were just fine with it. So
that's cool. Wait, hang on. Two Germans tuning in at the same time. Good morning, Robin Ian from the chat from Germany. Denny, early in the morning in Germany. Love waking up and seeing Robin Ian.
I want to go back to Germany really badly.
That makes me smile.
I really liked Germany. I went there because I was studying in Norway, and so I stopped.
Nope. I'm stopping this. I know that you want to go down this road. I feel it. I feel it. I
stopped in Germany for Essenspiel, but Germany was lovely. I love Germany. I stayed at this little bed and breakfast, and I just ordered the schnitzel, and they were like, "You will have a beer," and I was like, "No, I'm good." And they came back with this giant beer anyway, and I was like, "I said I'm good." They're like, "It is free. No one eats schnitzel without a beer." And I was like, "Okay, I guess I'm having a beer then." Germany was lovely. Everyone I met there was super nice. I totally want to go back. So, yeah.
Thank you, my friend. I very much, because that you the chat is terrible. Do it. No. The thing is, Ian and I know each other well enough that I know where he's going immediately. And it's like, nope, this is a 20-minute tangent. We're not doing this right now. Okay, so state of New Mexico by its special prosecutor, Carrie Morrissey, who respectfully submits the motion to reconsider dismissal with prejudice in support thereof. The state submits the following. And then she proceeds to go on.
And then there's 52 pages. And not only is there 52 pages, there's exhibits 1 to 4, which is like 300 pages. And exhibits 4 to 16, which is like another way too fucking many pages.
Yeah. It's a lot. It's basically a 500-page motion. So introduction. On July 12, 2024, the court dismissed the above captioned case with prejudice during trial for discovery violations, namely the state's failure to disclose ammunition collected by the Santa Fe. Pardon me. Oh my God. Wow. Santa Fe County Sheriff's Department on March 6th from Troy Teskey. the state asserts that there was insufficient facts to support the court's ruling that there was no violation of the defendant's due process rights. Hang on. The state asserts that there were insufficient facts. Okay. So court didn't have the facts to rule that way. Specifically, the state asserts that while the state may have suppressed the ammunition from the defendant Baldwin, the defendant was aware of the existence of the ammunition and the specific characteristics of the ammunition prior to trial. The ammunition is not favorable to the defendant and is not material to his defense. Here's the massive problem I have with this sentence, which Carrie Morrissey still does not fucking get. You don't get to exercise judgment.
Yeah. And that's the thing, is that sometimes the prosecution thinks something is irrelevant right up until it's really freaking relevant.
Yeah.
As an example, there's a cross-examination strategy that I call the Columbo, which is basically you pretend like you're a giant idiot right up until you... It's so much fun when you can make it actually work.
It's phenomenal.
But you pretend you're an idiot right up until you tie all of the pieces together. And by the time you're tying all the pieces together, the person has said so much stuff while they thought you were an idiot that they're just screwed. There's no way to get around it.
And the best is the moment when you see the realization hit them.
The realization where they're like, oh, I have not been talking to an idiot this entire time. And oh God, oh God, oh God. Yeah, that is fun. Like the point where they realize that suddenly this this cross-examination that they thought was real easy and real like light touch is actually going to hammer them so badly is just like, oh yes. But
I think that's why you and I like commenting on the same trials, because we have very similar styles in cross. Like that's my favorite cross, where I'm the friend. I'm your friend.
But I had a Crown prosecutor who, after I was well into the Columbo strategy, got up and objected to a question I'd asked like 60 questions ago. And the judge is like, that was asked a long time ago, Crown. And he said, yes, but I didn't realize where my friend was going with that when I failed to object. And the judge is like, well, then maybe you should consider lawyering, sir.
Yes. So this is called chess. And back when the white player makes his move, the black player has the opportunity to make their move. And again, chess pieces. So at that point in time, you actually have to anticipate how the board's going to look 6, 7, 10, 20 moves from that juncture.
Yeah.
You have to view the pieces on the battlefield and move yours accordingly and understand the risks of allowing a question to go forward without objection.
Sometimes I've objected to questions that like the judge is like, Mr. Runkle, why? And I'm like, this is background. I'm like, it is not, sir. And, you know, they're getting it through in hearsay. They need to get this through direct evidence. This is an important point. And the judge goes, okay, I'm going to allow the objection because it is hearsay, although I don't know why. And later the judge is like, oh, I get why.
Well, and to the point the chat's making, this isn't really a true tangent, because here's the thing that Carrie Morrissey did wrong. Carrie Morrissey played a different role in this trial than she's ever played. She is a trained defense counsel, which means that that's her experience. That's what she's done for her entire career. Defense attorneys don't have an affirmative obligation to disclose shit. You're
sometimes they do, but very rarely.
You're defending. You are defending. The state has the obligation and the burden at every single stage. You don't have to give them advanced notice of what you have all the time. You don't have to, like, let's say you have this magical impeachment evidence that you want to impeach their witness on. You don't have to turn that over. If they want to put a witness on the stand that has a known record of lying, you don't have to tell them this witness has a known record of lying. You can completely ambush them. Very different than the prosecution. prosecution has an
prosecution's got to
affirmative
give you
obligation.
everything.
Exactly. If the prosecution, for example, that same example I gave you of if me, a defense attorney, knows that the witness the prosecution is about to put on has a known record of lying, I don't have to turn that over. But if the prosecution knows that the witness they're about to put on has a record of lying, they have to provide that to me. They don't get to impose their own judgment on whether it was a lie or was not a lie. They don't get to impose their own judgment on whether the information is relevant or not relevant. And when they do, when they step in and they impose their own judgment, they're playing a big game of fuck around and find out. Like a massive game of fuck around and find out.
Mm-hmm.
Because if they fuck around and if the information is relevant and they withheld it, the find out part is dismissal. And Carrie Morrissey played that game, fuck around and find out. And there was information that she, in her opinion, viewed was not relevant. I don't know how she reached that conclusion based on the information we discovered, but she viewed it as not relevant or exculpatory. And because her interpretation was as much, she just didn't turn it over. Actually, what's worse, she went one extra step. She knew it was being filed under a separate case number.
I don't know if she knew that.
It's gonna be. How about this one? The knowledge is imputed to her as an actor of the state.
Yes, that is true.
So as an actor of the state, information in the state's possession was filed under a separate case number. So when the defense asked for everything relevant under this case, these other items under the separate case number just would not be shown. So there was a whole lot of fuck around. And Judge Summers, one of the reasons I love her for this,
She's like, is now time to find out.
she brought the find out. Like, she was like, no, you're not doing this. And that's why this case is an example of one thing that pisses me off about prosecutions is you guys have to be perfect.
Mm-hmm.
You have to be better. You have to be better. We expect more of you because you have the power of the state. You can't fuck around with it. You can't use it to just. It drove me nuts to actually see Baldwin. It hurt me to watch that case dismissed because I thought I fundamentally still believed there was guilty conduct.
Yep. I hear you.
But it was the right call to dismiss the charges. So,
it
moreover,
absolutely was.
the state requested court ordered defense counsel to provide a description and all documents related to when and how they learned of. Oh, honey. I haven't read this motion yet. Are you fucking kidding me? Are you fucking kidding me? The state requests the court ordered defense counsel to provide a description and all documents related to when and how they learned of the Tuskegee ammunition so that the court may properly consider prejudice to the defendant and a record for possible review by a higher court can be created. He forget who she is.
Here's the thing. I think she's trying to chase down an issue, and I don't know that she's necessarily wrong on this. My suspicion, and it's a suspicion, is the defense knew about the Tuskegee ammunition ages ago. And waited to see if she would fall into basically an ethics trap.
It was
and
planned.
She's basically saying, hey, if that is, and here's the thing, if that is the case, and they knew and had access to the Tuskegee ammunition and just decided to play a game, then I agree that would be a problem. Here's the thing, though. The time for that was at the time.
I was going to say, this is late.
Yep, you missed your chance. So, yeah.
Finally, the state requests the court reconsider the language in the court's order granting defendant Alec Baldwin's expedited motion for dismissal and sanctions under Brady, Giglio, and Rule 5501, New Mexico rules concerning the veracity of witness Maria Popple. Maria Popple was roasted. There was no. She just outright lied.
I mean, it's bad.
I feel like, and not just lied, I feel like if there was one part of Judge Summers' ruling that I really, really, really agreed with, it was that Carrie Morrissey knew damn well she was asking Marissa Popple to give testimony that was not truthful. And that just rang very true to me.
It's tough.
It's very hard to admit. So she goes on for 52 pages. Shall we take a broader look? Let's take a broad look at all 52 pages. Oh my gosh, they're beautiful. Look at all the photos of everything involved. And there's probably a lot of very good legal argument in here. But it's 52 fucking pages. Look at this shit. Look at that. Look at that. Oh my God. So, in Fairfax, the court where I practice most, you know what our page limit is?
10?
5.
Shit.
They don't fuck around. 5 pages. Now, they'll give you leave to write 10 if you want to, but you know what you have to do? You have to ask.
You got to ask for it.
You got to say, Judge, this issue might take me more than 5 pages.
Here where I am, for a lot of appeals, your limit is like 30 pages for the appeal. And you will be granted leave to file extra pages. Basically never.
Yeah. See, for example, we will routinely get, and people are asking like the 5-page thing. For complex things, so Court of Appeals, we get 30 pages. That's for appellate briefs. That's like asking a higher court to completely review all the case law back to the nth of time. Lawyers need to get very efficient in how to write their arguments. It's a skill you have to learn. So this goes on for 52 pages of a lot of non-legal argument, but factual distinctions on what is or is not a bullet that looks similar to this and that. And honestly, we saw a lot of this before. Ian's probably going to break this down to you in greater detail during one of his videos, because we're 4 hours and 30 minutes into mine.
Oh, and mine will probably be 4 hours and 30 minutes.
And it's just not possible to get through all of it. So there's a whole lot in here that says that I don't have to turn things over that aren't exculpatory because I assessed they weren't exculpatory. The part where I had fun with this was the media. And the media ran with an article that said, oh, no, go away. No, I don't want that yet. This one. And ABC was really quick to take it down, so I screenshotted it. So this was the first article that ran that I saw on this topic. Judge denies bid to reopen Alec Baldwin Rust case because motion was too long. That's the headline. The 52-page motion exceeded the 10-page limit, the judge said. So this is your mainstream media, folks. This is when you get those broadcasts coming across your phone as these highlights of headlines. This is the quality reporting you can expect, right? Right here. the judge denies the reopening, we are not going to reconsider this. That's what this article says. A New Mexico judge has denied an attempt by the prosecutors to reopen the involuntary manslaughter case against Alec Baldwin over the fatal on-set rush shooting because the state's motion was too long, court filings show. Does it? They go on, yada, yada. Everything goes through the substance of the case. And they actually, the problem is, here's the thing. This is the problem where the newspaper's an idiot or the press is an idiot. So they actually quote from the damn order. Given the procedural posture of the case, the court must enforce the local rule to regulate the court's docket and promote judicial efficiency. But they didn't actually cite the fucking ruling.
Oh, they never do. Do you need the ruling?
Well, wait. Look, more. So it's all that evidence withheld, yada, yada. I have the ruling. I just screenshot this for fun.
Oh, good.
Because they corrected it within about an hour. So the ruling. There it is. What does the order deny? So the court, very wisely, perceived the lengthy motion as being a request to the court to say, hey, I'd like to exceed page limits. So the court was like, I'm not going to let you go over this 52. Like, you got 10 pages, honey. Order denying state's motion for extension of page limits to state's motion to reconsider dismissal with prejudice. This matter comes before the court. State's motion for extension of page limits to state's motion to reconsider. Having reviewed the briefing and being otherwise fully advised, the court finds, concludes, and orders as follows. The court rules on the filed pleading without hearing. Cool? You can rule in the papers.
And not only that, but she rules on it before the defense has to lift a finger.
They ain't got to say shit. On August 30th, the state filed a 52-page state's motion to reconsider dismissal with prejudice. The state additionally filed 387 pages of exhibits for consideration with its motion. That's a lot of fucking pages. I don't want to read that if I don't have to. The state did not obtain advanced leave of court to file its motion well in excess of page limits. Ian and I both talked about that. The local rule requires entry of an order of the court when a party seeks to file a brief in excess of 10 pages. See the local rule. A brief or memorandum shall not exceed 10 pages. I get 5. I'm fucking jealous. Not including the cover page, conclusion, certificate of service, and exhibits. Dude, my certificate of service is included in my 5 pages. This is bullshit.
Seriously?
Yeah, I'm not kidding, man. They make us
So
make
you
our
get 4
arguments
pages.
concise. So you know what I do? I lay out all of my arguments in my letters to opposing counsel that I attach as exhibits.
Makes sense.
And I just say see exhibit A. God, I hope there's no judges. I hope there's no judges listening right now. I really hope there's not. The party shall follow. The party shall follow all local motion. Hang on. All local motion practice rules, including rules on page limitations and package procedure set forth in the local rule, given the procedural posture of the case. So this is where ABC cherry picked.
Yeah.
And it wasn't just ABC. We've talked about this before. The first publication that runs with the headline, AP, New York Times, they'll all grab it and republish it. So ABC ran with this headline of judge denies motion to reconsider. And everyone piggybacked. I mean, the Twitter feed blew up. Just
here's my question on this one. Can't you just
High
refile a 10-page?
Yeah. I'm getting to that in a second.
So it ain't denied. It's just we're denying your.
Yeah.
We're denying your
pages.
We're denying 42 pages of your bullshit, but you can still come back with the rest of your bullshit. You just got to pick the best 10 pages of your bullshit.
Yep.
Okay.
That's why I was laughing so much. So, given the procedural posture, the court must enforce the local rule to regulate the court's docket and promote judicial efficiency. As in, I'm not reading this shit.
Yeah. Fuck you, fuck off.
That is what this is. I am not reading this shit. You want me to reconsider my ruling? Make your argument efficiently. 10 pages. I'm not reading your fucking, I don't know, book, novel, whatever you want to call it. The court finds the state's motion for extension of paid limits to state's motion to reconsider dismissal with prejudice is not well taken and should be denied. So I'd like that the court creates this. This was not filed. There was no motion for the extension of page limits, but the court, in receiving a motion that's well in excess of page limits, rather than just deny the motion, they're like, I'm going to view this as your request to extend the page limitation. Here's what I usually do. The proper course of action is to do two things when you have a deadline. One, you file a motion to extend your page limitation. Two, you file your motion to extend page limitation and your motion for the relief you're requesting. So you file them both simultaneously. So the court can rule and say, I've read your motion. There's enough here. I'm going to grant you the extension and I'll accept this in the record. So it is therefore ordered that the state's, and this is where ABC really fucked up, the state's motion to extend the page limits with prejudice is denied. So ABC came back and corrected their mistake. But not after the damage is done. This is the problem that I have. Like you jump in and you make the judgment call and you run the headline, right? So where's this? Headline number 1. Nope. Wasn't that headline number 1? Where is it? Headline number 1. Denied, no new trial. All because the motion is too long. Do you see how that reads? For people that are looking for Alec Baldwin to face consequences for his actions, like people read that as the judge being too dismissive. Like, you're going to kick this out for page limits, right?
Well, the thing
For
is
people-
that you can, as a lawyer, absolutely lose a file based
Oh,
on
yeah.
page limit shit.
No, I know.
And
I know.
I've seen lawyers do it where it's like, you know, they leave a filing to the last day and then they try to file 35 pages. You know what the Court of Appeal does here? If you file a overlong document without
appellate courts don't fuck around. Appellate courts like punt and they're gone. You are gone. Do not pass go. See you later.
what the appeals court does here is they will quite literally, they're clerks. So the justices never see it. They will count out the 30 pages and tear it off.
Oh,
And that's what the justice gets.
oh my God. That's worse.
Oh, I mean, so I have, there have been cases where the justice is like, I am here to consider the first 30 pages of your filing of unknown length. And, if you don't think that translates to get wrecked, small, cute child,
It does. And Lady Drake right here, like I was going to say, it reads like the judge is being petty. It does. It depends on how you view the case. If you view the case as being properly kicked out, you're like, yeah, of course. If you view the case as being perhaps too quick to kick out because Baldwin did something wrong, you view the court as being petty, all because of how the article was written, the headline that's there. How disgusting is that? Because all they had to do was read the order. And what does the order say? What's the more appropriate headline? This.
Yeah.
Prosecutors must redo lengthy motions seeking to reopen the case.
By the way, for the people who think, like, lots of people don't realize that law is not like high school. High school, they would say you got to do a 10-page assignment. And you're like, how do I get up to 10 pages? Law, you get 10 pages and you go, oh, fuck me. Because you'd so
60.
rather
To trim it down.
Yeah. And I can tell you, recently I had a filing that I wanted to submit that was 3 pages over. And you got to figure out what you can cut, what you can reword to get down that 3 pages. And that is such brutal. Yeah. It sucks.
And Bolshevik Muppet, you're right. She does get to redo it. I can tell you what the outcome's going to be. Denied. But it's not going to be denied on the basis of just over page limit. It's going to be denied on the basis of the merits. Judge Summers isn't allowing Morrissey to reframe this case and re-argue this case. That's what she was saying with the docket constraints and limitations and the procedural posture. This case is done. The court made its ruling. You don't get to re-argue all over again. You get to ask me to reconsider, but you get 10 pages to do that.
You're done.
You're done. Like, you get 10 pages to ask me to reconsider what I took a long time to consider in the first place. It is an appropriate amount of time and pages to allow someone to articulate why the judge, the same judge that dismissed this with prejudice, should reconsider that ruling. I just had to do this in a case where someone filed a motion to reconsider and I had to respond. And I had 4 pages to respond.
And the other thing is, I think that her only hope at a reconsideration is if she can get the defense to be forced to talk about when they knew.
I don't think it's going to happen.
When did you know about the Teskey rounds?
And I think that comes back to timeliness.
The thing is, I don't think the judge is going to allow them to do it. But if
I get it.
If she allows it, like that inquiry, and they say, well, we actually knew like 9 months ago, then she might go, whoa, you didn't tell me that. Fuck you. Trial back on.
You misrepresented your motion to the court. That's what it is.
Yeah.
When you conveyed your motion to the court, you misrepresented facts.
Yeah. And, you know, I would not have granted this had I known. So, yeah.
But this part right here is why, honestly, I swear to you guys, why I am on YouTube. Like, it's one of the big reasons, because of this shit. It's this shit. It is articles that are published and released to the general population who have been fed information about a case that might be accurate, might not be accurate, but it is a quote unquote trusted news source. Trusted news source. This was ABC News. Trusted news source.
The thing is
with
the
a
news,
headline
when
like
they report
this,
on legal issues, is just so
always fucking wrong.
Yeah. Yeah. And it's so frustrating.
I'm sorry, I cut you off. I'm so angry about it. I'm sorry. I was jumping ahead.
I was not offended.
But Julia 543, this is 100%. Like, I loved what Rick was doing with Hangouts and Headlines. Guys, go back and look at Rick Hoaglaw. Look at his channel. Look at his channel. Go to the Hangouts and Headlines that he was doing. I want you to go watch those, because it's not political. It's not anything else. It is taking what the media is saying and comparing it to the actual truth. And right here, we have examples of what they have admitted to be the truth. within an hour. Within an hour. And here, let me tell you what their clarification is. Editor's note: this article has been updated to reflect that prosecutors must resubmit a new motion to the court to reopen the involuntary manslaughter case against Alec Baldwin. That motion must heed the court's 10-page limit on motions. An earlier version of the article incorrectly stated that a judge ruled against the prosecution's motion to reopen. This part, do you see how much damage can be done by saying conclusive result? Get another chance. Little bit different.
Well, the ones that just drive me nuts isn't like this one. Okay, whatever, not such a big deal. The ones that drive me nuts are things like Rittenhouse is one of them. Depp is one of them, where the media picks a narrative,
Incorrectly stated facts.
and they ignore everything to sell a narrative. And the thing is that they win either way, because if they spin everyone up with this angry narrative, and then it turns out that, like, you know, Depp loses, or that you know, Rittenhouse is convicted, well, then they get to be like, yes, we told you correctly all along. But then when it doesn't happen the way they say it, and so they end up with you know, Depp wins, Rittenhouse wins, what do? They say, this verdict is so unjust and you need to be so angry, because then they don't have to say, we got it wrong, we misled you about this case. What they say instead is, this is an injustice and you need to be angry. And because you're angry, you need to watch more of our shit with more ads. Whereas, like, when I expect my viewers overall to check my score. And so when I say, I think Maya's gonna win, check me on that. Because if I'm always wrong, like, and you know, I got people who were giving me shit when there was Rittenhouse coverage because I said, I think he's gonna win this. And they're like, well, he's an asshole. And I'm like, that can also be true.
Yeah,
those two things are not inconsistent.
They're not.
But I'm like, and you got to check this, right? And so when I say, like, this looks really bad for the state on Karen Reed, you know, check my work. Check, like, and if I'm always wrong, stop watching me.
That's fine. Like,
don't let me turn it around if I'm always, you know. And yeah, this is the thing. I started out saying Depp is going to lose because it's defamation of a celebrity. And then I started changing my mind as we saw evidence coming in. I was like, holy shit, I didn't actually think it was an interesting case to cover until I started to see some of the things. And I went, oh my God, there's actually a case here. This could actually be a thing.
It was boring until it wasn't.
Yeah, I mean, this is just one of those things. It's
so, but this part right here. So the
also,
first, like,
people changing their mind in the face of new evidence is also a good thing, and the media never seems to do that.
So the first sentence in this article, and you know, Robin, I want you to point this article out to your friends next time they want to argue with you about this stuff. The first sentence of this article, as it originally ran, I want you to tell me if there is a desired response that you are supposed to feel when you read this sentence out loud. Okay? Just tell me if there's a desired response that you believe the writer is trying to make you feel. A New Mexico judge has denied an attempt by prosecutors to reopen the involuntary manslaughter case against Alec Baldwin over the fatal onset Rust shooting because the state's motion was too long, court filings show. When I read that sentence, is there something in the way that that's drafted that's supposed to make you feel one way or the other? Because I can tell you for 100% certainty that is absolutely the case. As a lawyer who writes sentences and rewrites them because one way of writing it conveys the wrong message versus the other way, absolutely, there's intentionality in how that's written. So now I want you to we're going to go back to the new one. This is how the first sentence reads in the corrected article. Prosecutors must resubmit a motion seeking to reopen the involuntary manslaughter case against Alec Baldwin over the fatal on-set rush shooting because the initial filing was too long. Do you feel the difference? And I say feel because that's kind of how it's perceived. Do you feel the difference in tone? But also, do you still see how they maintained a certain slant in how you're supposed to perceive the information? That is what I hate. That one. I hate that. I like reading pleadings to you guys because I like reading from one side and the other. And I like Ian being here a lot because he and I can argue on both sides. And we will do that quite often. I'll pick a side that I don't believe in just to hear him argue hard on the other side.
By the way, Google Maps is right.
Oh my God. I knew you were going to fucking do that. Asshole. But that's where you end up. Oh, there it is. Dr. Moo. Damn it, Dr. Moo. You're killing me, bro.
We've got to follow up on that case because I want to see where that goes.
I do too.
I mean, there is the grand possibility that sympathy carries the day on that one and that they end up.
The law might work. Give me 1 second.
I'm just somebody says still team Rob. Rob is wrong. If I tell you to turn left at the intersection and you fail to notice that it goes over a cliff, that's kind of on you. Like a person who makes a map can't be expected to like know that the map is whatever. So yeah. I am probably going to have to, I'm going to wait until Rob comes back, but then I'm going to have to bail to make sure that all of my gear is ready to go.
I'm here. Yep, you got to do that. I was about to say before you jumped off, like just I want a supercut of that like Google Maps debate so that when people ask what it's about, I've got like a 2-minute thing I could just put up that's like the highlight of the peak of the yelling at each other, just so people can see how people can disagree all the time.
I mean, the thing is some people don't really get all the time that lawyers like to argue, and we get used to arguing in a way that doesn't mean animosity, right? Because if you take every disagreement personally, you will burn out on law really fast because it's just impossible to, impossible to anything, right? Everything you do involves an argument and so forth.
Christina B has a request for extra life.
Signed pictures of me and my nifty glasses. I guess I will try to figure that out. Yeah. So yeah, I gotta go. I gotta go make sure everything is staged because in the morning I'm gonna wake up and I can tell you I am going to be dead freaking tired. So I gotta make sure everything is just it. I pick it up, I put it in the car, and then I'm good because otherwise I'm just not gonna manage. So,
if this is true, C. Taylor, that Recovery Addict's son's wedding is tomorrow, that's pretty fucking cool. So I wish all the best to the happy couple. So, all right,
Ian. Says, Ian, are you nervous? Yes, all the time, but you do it anyway. So, I will catch you later. Rob, thank you for having me on. I missed you streaming because you've
Can
been
you give me a
so
call
busy
tomorrow? Like
packing.
when you're done with the shoot, can you give me a call, like an actual
I
phone
will.
call?
I'll give you a shout. But it might be a little. It might be a little while
That's fair.
because what I suspect is going to happen is I'm going to finish up, chat with some
Sleep.
people at the range, go home, sort of unpack, repack, restage to be ready for the next day, and then like sleep for like 2 hours. Then I'll give you a call because
That's fair.
yeah, I'll give you a shout where I can. But yeah, talk to you tomorrow and see everyone soon. So
Night, buddy.
good night.
Okay. All right. We're going to catch up on Super Chats and get out of here. So, back in the saddle for 1 week, and it's 1:28 my time in the morning and 4 hours and 55 minutes streaming. So, not bad. Hit the ground running, or so they say. Billy's Momzilla, how can Sarah Boone be charged with murder if he got into the suitcase willingly, morally guilty for not letting him out, but legally? Yes. One, there's a question on who zipped it closed, because he couldn't have gotten in and zipped it all the way closed by himself based on how that suitcase is. So there's who committed the final act that put him in there. And then also the video of her watching him in the suitcase asking to be let out. I think that's culpability. So I think you've got that there. Celine, you need a new P.O. box. I have a dog toy for Leo. I do need a new P.O. box. I have to move that over. I know there's stuff at the old one. I will try to get there over the weekend. The Sharpie, thank you very much. My oldest brother was in a TBI this summer, and my wife and brother fought current hospital and insurance company and seemed to have won. That is not a easy fought battle. Amazing what happens when you get state Medicaid office and AG involved. Holy crap, that's a story. Wow. The Sharpie. I mean, my cheers to you. That's a lot of effort. You know what? Drop me an email, lawandlumber@gmail.com. I'm going to be checking emails this weekend. I haven't in a while. And that's my apologies for that. But I'm going to check emails this weekend, and I'd love to read some more about what you went through. It's quite the achievement. TSN, thank you for the gifted memberships. Much appreciated. Analytical Blarney. Sandy, thank you for being the most amazing human on the planet. Thank you for all you do. Thank you, Rob, for all you do for the community. Sandy is an absolute badass. And Sandy, as are all the mods, every single person that's a mod for this channel does above and beyond. I mean, look, they've been carrying over me for the past 5 hours. And they do it graciously, with love in their hearts, with all that they can give, and they do it for you guys in the community that are chatting with us. So please thank the mods. Thank the mods. They're amazing people, all of them, every single one. I've had the lovely pleasure, actually, this past weekend, I had the pleasure of Sandy actually driving up to where I was with her husband and getting the chance to spend time with them briefly while I was on my trip. So they're great people. Honestly, all you guys are. What's crazy about this is I know that a lot of y'all have made really good connections with each other, and I hope they continue and manifest into wonderful things. But I have made connections with a bunch of you guys too, and it's a whole lot of really good people out there. I mean, really good people, like restore your faith in humanity kind of people. And it seems like every person I've met that's engaged in this chat and on this channel has been in that category. So that's a big cheers to all of y'all. Yeah. I'm happy to meet as many of you as I can. I really am. Light Queen. Yay, FNF while finishing my second diamond painting. Very relaxing evening ahead. Good. Glad you're having fun. Share a picture of it. J. Michael RN. Hi, friends. Hope you're doing well. J. Michael RN. I hope that you're not working the night shift. But the timing of your comment suggests that you might be. So Cheers. We doing okay? Twisted Puppet. Commenting on the first story reported on, Perry March was convicted of deleting his wife without a body. Joe Daniels was also convicted of deleting his autistic son without a body. So was Zachariah Anderson. So it's a tough case, but when you have facts lining up where there's no other alternative, that's what it is. I think that's what this case is lining up to be. E. Warner shouldn't ask for a licensed attorney. He is licensed, though. Patty P. Sarah invented a new font. Well drafted, though, right? That's a stylistic font. Kristen M96. By the way, did you see one of the Scheffler cops got arrested for? Yes, I did. For theft of money on a traffic stop. I did. One of the cops that was actually had arrested Scotty Scheffler got himself in trouble for stealing money during a traffic stop. Hang on, let me see if that's still up. Scheffler. Officer Javar Downs. Disciplined for not switching his body camera on during the arrest of Scotty Scheffler. Charged with stealing $4,000 from a criminal suspect. Well, that's, just goes to show. Rosebud, late, but way past fashionably late. I was early, but way past fashionably early. That doesn't make sense. R. Bauer, 25. Thanks for remember. Sandy, speaker name. There she is. Gifted 5 memberships. Thank you very much. And thanks for hanging out, by the way. Wonderful time. Yeah. Oh, mods are really cool. Like, I get the chance to talk to them a bunch, and they're really awesome people. Great stories. All of you guys have great stories. Honestly, you have life experience out the wazoo, but somehow you listen to me. Don't you wish there was like a forum where we could all just like hear all the life stories of all the cool stuff that happened? Yeah, it'd be fun. WW took my kiddo to the first concert ever on Sunday. They had a blast. They'll figure out later that Metallica in a stadium is not a typical first. Oh, shit. No. Front row balcony to Metallica in a stadium? Why'd you waste those tickets on kids? They'll never get it. They'll never understand. Why didn't it's a waste of tickets? That's not negative. That is just, honestly, it's just factual. Metallica in a stadium, front row balcony. How old are these children? Did they listen? Do they know Metallica? Do they understand what they just heard or saw or witnessed? I feel like the answers are no. I'm very jealous. Very jealous. Ian Paler, Paul Harrell left me a few bullets, dollars, and thoughts wiser throughout the years of watching his videos made and avoided purchases on his account. Paul Harrell was like I said, man was made of nails and brilliant, intelligent. Please go watch his channel if you haven't seen it already. DK Cripple, Pit Vipers, Runkle, you need a pair of Pit Vipers. I feel like he would say no, but I'll test him. I will remember that too, because I saw that and I wanted to ask him a couple times. I think he'll say no. Lynn Britton, 2 of my favorite guys is like getting the band back together. It was a great time. And a lot of it was sidetracks because we hadn't caught up in a while. Lauren Cremens, 19 years ago, met a GAL on an online game site. Oh, met a gal on an online game site. First time we ever chatted to anyone. Lifelong friends in New Jersey and Tennessee, and we're planning our next visit. Some things are meant to be. I don't disagree. So life's pretty cool. Puts you in a place where you don't expect it, but ends up being all right. More than all right. Honestly, pretty pretty fucking awesome. If you let life come to you, it can be pretty fucking cool. A lot of love, a lot of thanks to be thankful for. 20th Century Fox, Sarah Boone has remarkable handwriting, though. Actually, she does. Joshua, thanks again for another great FNF and have a wonderful weekend. Everyone, have a wonderful weekend to everybody indeed. Devin, well, spoke of you earlier, buddy. Glad to see you again, my friend. Friendly reminder about my text message. You mean about Extra Life? Yes, I got it. Hang on. No, it wasn't about Extra Life. Yes. Yes. Devin, I am reading your text message. Operation Devin DC, good to go. We're good. I've got you. Shout out to Dr. Moo, my favorite online find. Dr. Moo is a badass. And honestly, I know he's going through a lot. It's a whole lot, my friend. And I hope you're doing okay. I really do. Really do. So I love the participation. I love the friends. I love seeing you interact with friends in chat. I love all of it, man. A whole lot of people in chat supporting a whole lot of people in chat. And honestly, when I'm talking about law, I see passing glimpses of all the love you guys give today to each other. It's really fucking cool. It's really cool. See, like this, KPT, my first concert was Garth Brooks. What the hell is that? You're going to go and see Garth Brooks as your first concert? Honestly, Tim McGraw was mine. Kenny Chesney opened for him. So fair. My best friend's kids are like twins of your kids, Debbie. The MIDI metalheads. Julia 543. You're a family lawyer when GAL is gal. Is in guardian ad litem. Yeah, when gal is in I read that as GAL first, but yes. You know you're a family lawyer when you read GAL as GAL instead of gal. You know, it's just how it goes sometimes. All right. So happy birthday to Amber. Happy birthday, Amber. Cheers to you. I hope you have a wonderful birthday. Get out, celebrate, have some fun. Live the next year of life as if it was your best and finest and most exciting ever. Honestly, less excitement would be more fun right now. Just happy good years. Let's just pray for that. All right. Going back to Josh's comment. Thanks again for the great FNF and have a wonderful weekend, everyone. I started that, brought it back up because I do want everyone to have a phenomenal weekend. It is now officially September 7th, my time, 1:41 a.m. We've been going for 5 hours and 7 minutes, which means that we are officially back in the saddle. Cheers to all of you. I hope you have a great weekend. Please go out there, make something, do something. Honestly, just make something that makes you happy. I've got to make a shop. Oh, baby. I've got to make a shop. And I'm going to have some fun doing it. So cheers to all of you. I hope you have a wonderful weekend. Thank you for being here. Please hit the like button and subscribe on your way out. I will set up a redirect to Ian's latest video so you guys can see it. Again, please go support my guest, Ian Runkle the Bailey. Please keep supporting each other. Be good people. It ain't hard. And make something. You'll feel better, I promise. All right. Good night, guys. I'll see you next time. Bye. I got to run the outro. Rob, run the outro. Don't just hit end stream. Run the outro. You step away for a week and a half and you're just completely lost. Anyways, say it again. Good night, folks. Bye.